Lordship, I beg to mention item number 24 and 25, Lordship.
Yeah.
Lordship, matter will be taken after a week, Lordship. The senior standing counsel is out of station, Lordship.
Arjun.
Oblige, Lordship.
My lord, I am mentioning item number 33, my lord. My lord, here, my lord, we pray for 3 weeks time to file our reply, my lord, counter affidavit. Respondent 4S, 5S file an affidavit, my lord. I pray for 3 weeks time.
Yeah. So what do you want?
3 weeks time to file counter.
Arjun. Yes.
Wait, please, Your Lordship. My lord, item number 22, my lord, we have filed an additional affidavit. We will be allowed to bring it on record, my lord.
Call for the additional.
Bibliography.
May please, Your Lordship. My lord, I beg to mention for listing of for hearing matter, my lord.
Hearing matter.
My lord.
What's the urgency?
My lord, urgency, my lord, the hearing case is relating to the provincialization and the case is pending, my lord, since 21, my lord.
22. 22. 16th of May.
Highly obliged, Your Lordship.
May I please, Your Lordship? I'm from the petitioner side. I beg to mention IA number 817 of 2020 listing for the matter for the urgency.
You want to get a matter listed?
Listing.
When?
Finally, Angus date
Which date?
26.
26th. What's the urgency?
So, condonation of delay.
Condemnation of this can be listed at any point of time. Next week, we will get it. Yes.
May it please your lordship, with the consent of the other side, I beg to mention item number 37. May I pray that the matter may be taken on 22nd of May, your lordship? Lords,
Urgent 22nd of May.
deeply obliged, your lordship.
Thank you. 37, you have mentioned 37.
37.
Yes, 37. Okay, fine.
May it please, Lordship. Well, I beg to mention item number 40, my lord. Here, my lord, I'm from the department, my lord. I supposed to file our affidavit today. It is, I will filing it today, my lord.
After a week.
Oblige, Lordship.
May I please, Your Lordship? I beg to mention item number 49 manner, which concern of the other side and for the appellant manner. May I pray for agenda matter for a week manner?
49?
49.
You are here for?
Supplementary list. Appellant.
This one is. It's going to be meeting measure.
Supplementary. 230.
Arjun.
Lordship.
Yes.
Oblige.
Daily list for orders item 1.
My lord, I pray for 2 days time to file the amended memo.
It was ordered.
Yes, Lordship, there was.
3/8/2023.
Yes, Lord. I had in fact got it filed, but it is not on record.
Then concept of the petitioner prays for and granted last opportunity to comply with the order dated 3/8/2023. Last opportunity of 1 week.
Item two,
That's it. May I please? Last occasion, my learning period was asked to obtain the instruction order service of CS number 7 has been served.
Yes, my lord, it is served, my lord. It is served on, my lord, 3rd of April, through the principal, my lord.
Have you filed any compliance report?
No, my lord, today, actually today morning, I have received the instruction, my lord. I can file it, my lord, by tomorrow.
Nikhil and council, appearing for the education secondary department has submitted that the notices upon the respondent number 7 has already been served. He plays 2 days time to produce the service report on record.
Yes, my lord.
Yes, Lord,
Obliged,
so-
obliged.
item three,
Respondent number 2.
My lord, respondent number 2, we have taken Dusty, my lord, and to that effect, today itself only we could file the affidavit, my lord, for the compliance of the, my lord, Dusty service, my lord, but that is not on record, my lord.
Lordship, may I submit one thing, my lord? In this matter, the deputy commissioner of the concerned district is the necessary party because matter pertaining to the enforcement of land, my lord. We have filed our affidavit, but petitioner have to implead the deputy commissioner of the concerned district, my lord.
You have raised this objection in your counter.
Yes, lordship, in the affidavit,
No, no, my lord, DC is not a party, it is the board, Assam Board of Wakaf, my lord, can look into the entire affairs as per the Wakaf Act, my lord.
For them to
My lord.
include any person as a party will see if. it
My
is
lord,
a
my lord
necessary
can
party, then
examine and
we'll
can it
give
require.
them a chance.
Lord, I have filed my affidavit also.
That is up to them
My lord.
to include the party.
In their affidavit, they have admitted, my
Lord,
lord, that
consider
the
bringing the
enforcement is there. my lord.
Has submitted that the notices upon the respondent number 2 is already been served and proof regarding the same will be filed. Today itself, you are going.
My lord, today itself we have taken, my lord.
After
Fine.
for admission.
Obliged, my lord.
The service of notice upon the respondent number 2.
Obliged, lord.
item number four,
My lord, in this case, I have to take steps, my lord. I'll take steps within 48 hours. I have to take steps, my lord, in this case. I'll take it within 48 hours, my lord. Instruction will be given.
In council appearing for the petitioner is granted a week more, a week more time to get the notices served upon the, to take steps for service of
Okay.
notice upon the respondent who registered post AD.
Most of it, my lord.
item five,
May it please your lordship. My lord, your lordship would be pleased to take IA. IA number, my lord. IA number 3846 of 2023. My lord, my prayer before your lordship is this.
They notices.
Respondent number 8 and 9 may be struck down.
8 and 9,
Maybe struck down, man.
strike 9.
Yes,
Wow,
ma'am.
why?
Because, my lord, this school, my lord, not in existence. My lord, this is amalgamated with another school and managing committee is also not there.
That
Headmaster
another
is
school-
also not there.
That another school is already implemented as party.
That another school. Another school is not implemented as party. My lord, in the main case also, it is not implemented as party.
Then why you have implemented them here?
My lord, my lord, I have implemented what in the writ petition. So, my lord, here, what happened, my lord, in the writ petition, this new school was not implemented as party.
Was the dispute about?
My lord, dispute is regarding this. My lord, I was appointed as tutor in 2021. Thereafter, my lord, my appointment was challenged before your lordship. And ultimately, your lordship referred the matter to the director. And director decided in my favor. Challenging the order of the director, connected writ petition was filed. And Honorable Single Judge interfered with the order of the director. So my lord, in pursuance of that order, my lord, my salary is stopped.
You have filed this, how you have explained the delay of 337
My lord,
days?
it's 37 days, my lord, your lordship will turn to page 8, my lord. Page 8, para 2A, 2B, 2C. What happened, my lord? I have appointed one, I have filed caveat. But that learned advocate for the caveator, my lord, was present in the court when the order was passed. But unfortunately, I was not informed. When I communicated to the advocate, my lord, the advocate said that, you see, I tried to communicate, but I could not communicate. That is the reason of delay, my lord. 337 days. In this case, your lordship, I am referring for respondent number 1. I have objection, your lordship, and I will file my objection within 3 weeks.
Just confirm.
Service is complete, my lord.
Understand. On 22nd of December 2023 and 4/3/2024, the counsel for the applicant was directed to take fresh step, to take steps for service of notice upon the respondent number 8 and 9. As per the office report, step has not been taken till date. The counsel appearing for the applicant has made a oral prayer that the name of the respondent number 8 and 9 be strike off from the array of the non-applicants as non-applicants because the school to which the respondent number 8 and 9 are represented is no more in existence. Full stop. At the oral request of the learned counsel for the applicant, the name of the non-applicants number 8 and 9 is strike off. Is ordered to be strike off at the risk of the applicant. Learned counsel appearing for the respondent number 1 placed some time to file counter to the IA. Time plate for is granted list after 4 weeks.
Oblige. 2 weeks, huh?
Item 6.
Oblige, your lordship.
Applicant, counsel for the applicant may file the amended cost title. Yes, Mr. You may file the amended cost title.
My lord.
Amended cost title.
Yes, ma'am.
Amended cost title within a week.
In item number 6, my lord, here in this case, my lord, office not go to show that, my lord, they are with service report, my lord. In respect of
Item number 6.
6, my lord. That is regarding, my lord, their water body, that is Dorsala bill.
In respect of this service of notice upon the respondent number 1 to 9 is awaited.
Probably, my lord, my learned friend is probably appearing, my lord.
You are appearing, Mr.
Yes, lordship, from today onwards, I will appear and would like to file detail if
On behalf of all the
most of them are state government agencies, lordship. Yes, lordship, for all.
Mr. Advocate General is appearing on behalf of assisted by so and so is appearing on behalf of all the respondents. He placed some time to file counter to the petition time plate for his granted list on
Let it 4 weeks time maybe.
list after 6 weeks.
Development.
Deeply.
Small prayer, my lord, for spending council name of GMC, GMDA, GDD may be reflected in the cost line.
Yes,
Name of spending council, GMC, GMDA will be reflected in the cost item.
And smart city.
Smart.
Okay,
given,
We'll give it, lordship.
name-
reflecting the causes.
Matter listed by reflecting the name.
by reflecting the name of son.
GMC, GMDA smart city in the context.
So that we don't miss the case, lordship. That is the only reason, not.
Service
Highly
of
obliged.
the completely. Service is given.
Item 7.
None present, rest of the 4 weeks.
Item 8.
Your lordship. My lord, the office
The respondent number 6 have not been.
is not been served, my lord. What I pray is that, my lord, I may be allowed to serve by the team, my lord. I may be allowed to, my lord, to serve by the team.
I think so, this was already allowed.
Dusty is not allowed, my lord.
The notice will be issued when the AD. Just the talk with AD. Trustee is actually in addition. It is not a service mode recognized by. Service mode. अभी तो इसके कोर्स में जिले तो 10 दिन आ गया तो नहीं आया तो बहुत आया वो हाँ पहले तो 10 दिन में सर्विस एक्सेप्ट नहीं लेकिन आ गया तो इंटीग्रेशन पे आ गया फिर नहीं किया तो we'll await return of notices for 2 more weeks, then we'll.
My lord, I have one objection, my lord, regarding this status quo, my lord. So, my lord, your lordship granted status quo up to this date, my lord. What happened, my lord, in the tribunal, his appointment is cancelled. Next, my lord, the Honorable High Court, single judge also did not interfere with that order. So he is no longer in service. So, my lord, if status quo is given, he will continue, though his appointment is declared as illegal and his appointment is cancelled. So, my lord, what happened, my lord? After the order of the tribunal and the learned single judge, my lord, he cannot continue as headmaster of the school. And otherwise, what will happen, my lord? A total relief will be granted to him, which cannot be. And regarding running of the school, my lord, regarding running of the school,
Just a minute, the notices upon the respondent, as per the office report, notices upon the respondent number 6 have not been served till date. Let fresh notice be issued to the respondent number 6. The concept for the applicant is directed to take steps to take step for service of notice upon the respondent number 6 by registered post AD as well as Dusty within a period of 3 days. So the notices are made returnable after 4 weeks thereafter. Let us see.
My lord, the
Then
interim
come
order is still.
my
today, my
lord, my humble submission before your lordship.
File a
Regarding
counter for vacation of the stay
status,
order.
status quo may be stopped, my lord. Status quo may
You
not.
file a counter to that, we'll consider that.
Hello.
You file an application for vacation of the stay order or for discontinuation of the status quo order, we'll consider and pass an order.
Apply, sir.
My lord, the interim order is otherwise still today, my lord, till the next.
Interim order if any to continue till next stage.
My lord.
Apply, sir.
Item 9.
There's an appeal preferred by the state, my lord. While preferring the appeal, there's a delay of 610 days, my lord.
Particular explanation.
Yes, my lord. Paragraph 2, 3, and 4, my lord.
There is no explanation at all.
But-
You have raised some ground on merits.
But in paragraph 4, 5, 6, then
5, 6, what
7, 8, my lord, there is a correspondence
joint committee, there is several.
entrusted to the joint committee, my lord, to
With legal advice for before the state of the criminal correspondence with the legal policy. Taking the scope of your custody, the criminal law. May enforce in case of the No, there is no explanation regarding the delay.
my lord,
If the order of the learned signature can't be implemented, can't be implemented. They have simply said, initiate the process and the persons are not coming in that process. You can very
otherwise
well
it is
pass an order.
otherwise it is unimplementable. But
What's the
subsequently,
order? Consideration order is there. What was
That-
the order?
that consideration order, my lord, it is though reflected in the pleadings, my lord, it is not in the record, my lord. I'll bring it on record, my lord, because it has been
You must
reflected in.
have filed the appeal. Which page is the order? Impugn order, single judge's order?
Impugn order is at, my lord, page 171, my lord. It starts from 179, my lord.
The only observation by the respondents are not directed to carry forward and bring to the said process to its logical and at the earliest. That's the only direction.
But
From such
the
point
prayer-
of the
prayer-
request may have the benefit of regularization these few days. We have taken note of the attention we made by the regarding certificate. To be cabinet decision made even after further notification similar nature of the. No explanation from the left. There's no explanation, sufficient explanation and otherwise also on merits also we don't,
There is, my lord, regarding the prayer made in the petition to consider the case under the Act of 2017, my lord.
whatever it may be,
But learned single judge went beyond the prayer made in the petition
you can always mold the release.
and
as
gave
per
the,
as per
granted the benefit
stipulation.
under the,
But anyway, there is no hardly any explanation in this IA for condonation of delay.
as
So,
reg-
we are not going to test the merits. There is no explanation. 337 days you have simply said. 610.
610 days, my lord, 610 days.
Oh, it's too much. Nothing.
My lord, to that effect, my lord, may I pray for some more time so that I can,
Having gone through the IA number so and so, we are of the candid view that no explanation, no satisfactory, no explanation, much less satisfactory explanation is given by the is pleaded in the IA for condoning the delay of 610 days in filing the connecting appeal. Learned counsel appearing for the applicants placed for and granted 4 weeks more time to file an additional affidavit explaining the delay in explaining the satisfactory reasons for delay in filing the connected appeal.
Obliged, Lordship.
Item 10 and 11.
14 days delay,
Yes, Lordship, 14 days delay between the appeal, Lordship.
issue notice returnable on so and so.
Obliged, Lordship.
Item 12.
May it please your lordship, my lord, there is 6 days delay in filing the appeal, my lord.
Same order. Issue notice,
Obliged, my lord.
Item 13.
My lord, this matter relates to one-time settlement that was in connection of a loan that was granted in favor of the respondent number.
how much amount is due?
Actually, out of 56 lakhs, already we have cleared the amount. We have paid the entire amount, but not in time. Because we could not, it was, the agreement was in between the principal borrower and the respondent bank, my lord. But the principal borrower failed to pay after paying certain amounts. Then my lord, I petitioner 1 and 2, husband and wife, they are the cancer patient, my lord. And they had to, under compelling circumstances, they had to give their properties in mortgage. Only for their treatment and for their financial crisis. That's why this is the second litigation, my lord. And the first litigation has been preferred, and ultimately, my lord, they 56 lakhs it is settled. Now we have paid, my lord.
How much amount is
Your lordship, 95 lakhs and odd amount, your lord.
today?
Yes, your lord.
My lord, that is another very important point. 95 lakhs, whatever, my lord.
You can't.
No, lordship, I want to draw the
choose
attention.
that.
Lordship, I
If
want
you're
to.
disputing the amount, then we.
No, my lord, that is wrong submission. Because I want to make it clear. Lordship, kindly see what they have paid, my lord. My lord, in IA application, we have that is we have given they have submitted in IA affidavit, and we have given the reply. Lordship, the annexure 3, my lord, page 69, our affidavit in reply. Fifteen 12/2023, 107 page number, my lord.
That affidavit in reply is not there.
My lord, 1,45,000 was balance.
It is not on record.
Your lordship, total outstanding? Yeah.
Which the affidavit which they are referring to.
My lord, honorable court has directed me to pay balance amount of 1,45,000 via order dated 15/12/2023. Accordingly, we have paid in time. And my lord, there is a second OTS. Honorable court has given us to liberty to sign the second OTS documents. Because second OTS document, my lord.
Earlier you approached the court.
Yes, your lordship.
When?
Yes, your lordship, in the year of 2021.
Annexure
by
4,
filing
my
of
lord,
writ
page
petition
110.
number 3477/2021.
Page 29.
Page 29, your lord.
Yes.
And accordingly, by this writ petition was disposed of on the ground that the compromise has been happened between both the parties. That is at page number 31.
Third, when the petitioner assumed guarantor as a loan amount from the individual account was not to be paid. this, this statement, your, bank was also representing at that time.
Yes, your lordship, and thereafter page number 31, compromise proposal was signed. And-
One, yes.
Your lordship, and accordingly, the bank has settled the account at rupees 56 lakhs.
Okay,
And they have waited, then there is a condition in 32 number page, last paragraph, that if the borrower fails, then this compromise proposal stands vacated.
fine.
And your lordship, but they have not paid the amount by 22/1/2022. And we have waited till 2023, when we have issued a notice for the sale notice under the Surface Act, then only they come down with an writ petition again.
My lord, another very, I want to draw the attention of this honorable court. What happened? Actually, this OTS proposal,
very first
only
prayer
18
is-
days time is given. They have deviated the guidelines of Reserve Bank.
What?
Only
So
18
you-
days,
you
not, my
can't-
lord,
Why you have entered into this OTS
No, no.
agreement then?
pardon, my lord.
Why you have entered into that?
My lord, 18 days time was given.
So why you have entered into that agreement?
My lord, actually, what happened, I want to submit the principal borrower, whenever he failed to, after paying the first amount of rupees, about 13 lakhs, then he failed to pay, then the guarantors, we are being the cancer patients. I had to, lordship, what happened? I came in the picture. Because it was the duty on the part of the principal borrower. My lord, they have deviated 1 year time is should be given. And another sake
So
was.
why you have agreed for that, then it is
My-
in a,
My
after
lord,
all,
my lord,
it is an
my
agreement.
lord, principal borrower, they have not taken any steps against the principal borrower.
Whatever, that is their choice, sir. That is settled law. It's a collective responsibility.
Liabilities cost.
My lord, it was
it is
in
for the
between the
bank to
principal
pay.
borrower, first of all, then we had.
That is settled law. You can't argue on that point.
Lordship, kindly come to the position.
$56 lakhs have been paid.
You-
You have received 56 lakhs.
Your lordship, as on date today, we have received, but after filing of this instant writ petitions. That is as per
This
the order of,
total outstanding was 56 lakhs.
no, your lordship, total outstanding was much more.
But you have settled your account at
In the year of
56
2021 year.
In the year 2021, you have settled that amount by 56 lakhs on an amount of rupees 56 lakhs,
Yes, sir.
which they have paid up to what date?
This is in, as per the last order of this.
My lord,
Your lordship, in the month of January or February somewhere, your lordship has been
January, February of what?
2024, your lord.
2024.
Yes, your lord.
And they were supposed to pay the amount?
In the year 22/1/2022.
my lord, bank has extended the time all the time.
Please, let us.
Yes, sir. Sorry, my lord.
The bank has extended time when?
Lordship,
No, your lordship.
kindly use the microphone. I'm sorry. For some hearing
The
purpose.
bank has granted time, when the bank has extended the time for deposit of money.
My lord, from time to time, whenever.
Where is that order? Where is
My
that?
my lord, I have.
Any letter or order?
Your lordship, till issuance of the sale notice, there was no extension. And thereafter, there was no extension, your lord.
Yes.
No,
After
lord,
January 2022, bank has not granted any extension.
No, your lord. There was no extension. They have not seek for and we have.
Then when you have not granted any extension and they have deposited the money, why you have accepted
No,
the
no,
money?
your lordship, they have not deposited the money. Only after filing of the writ petition and as per the order of this court, only they have deposited.
What is the order of
And
the court?
your lordship, 21 lakhs,
my lord, there are some contradictory statements. Once they have given second OTS proposal, 42 lakhs, again we will have to pay. After deducting my down payment of 18 lakhs, 27 lakhs, again they have stated now, I will have to pay 95 lakhs. We have paid, my lord, about 2 crores, about 1 crore 45 lakhs. Out of 1 crore 20 lakhs. Principal border, they have not taken any steps against the principal border, my lord. It is very arbitrariness, it is proved, my lord. My lord, 1 point, my,
मेरा ये कहना है कि ये भी हुआ है इसका बहुत सर्कमस्टेंसेस एंड इसके लिए कितना पेनल्टी उनको लगा है वो देख सकते हैं बाकी और क्योंकि प्रिंसिपल एवरी अमाउंट दे दिया है ये भी क्या पेनल्टी ये पेपर से इसमें सिचुएशन प्रॉब्लम भी जाएगा पैसा लेगा अगर ये आदमी हो सकता दोनों आदमी वही में क्या
This now this amount again amount comes to 90 lakhs. How?
95 lakhs, your lordship.
How?
Your lordship, the original default amount is more than 1 crore rupees and
Okay.
it was settled at 56 lakhs. Once it has been defaulted, then the said amount was again reached to after deducting of the payment of 35 lakhs and odd. It has again come
Take
back to.
instructions from the bank. And yes, certainly there is a delay in payment of some money or the due money. But since now the court has interfered with it and they are the cancer patients, you impose some penalty, and ask them to give the
Yes,
penalty.
yes, your lordship. We have considered and we have given them one OTS offer also.
Where is that?
That, yes, sir. That is at affidavit in reply, page number 74, your lord.
74.
Yes, your lord. That
Yes.
is on 30th 11/2023.
Yes. What's the offer?
That is 42 lakhs again.
Why 42 lakhs?
Your lordship, always there is an
After
issue,
deducting
so
15
we have
lakhs.
to get the amount according to the bank's internal guidelines and all. Because
Give some leverage to them. You again propose some amount and it's okay, 15 lakhs more amount. You take your instructions. 15 lakh more amount. Will
I
grant them time to deposit that 15 lakhs and then only you can proceed. If they fail to deposit, then you may proceed.
I have to take your.
Take instructions. Yes, Mr. Gonsil.
Yes, my lord.
Now you have to pay some penalty for this delay in payment. You have to pay some penalty for
As per Annex 3, my lord, in the second OTS.
whatever it may be, you have to pay some penalty for that and we propose that you pay 15 lakhs amount and then only will interfere. Penalty as
Out of
penalty amount.
15 lakhs.
If you are
15 lakhs,
ready
my
to
lord, I
pay-
have already paid 15 lakhs down payment.
Whatever it may be, again 15 lakhs, if you are ready to pay, then it's okay, otherwise not. Complete your instructions.
15 lakhs, my lord.
Yes.
My lord, some time may be given.
Yeah, we are granting 30th of May.
What, 2 months time may be given.
What 2 months? At least first complete your instructions.
Yes.
30th of May.
Yes.
You complete
Yes,
your
I'll
instructions.
give
If
you
you are
some.
ready to pay an amount of rupees 15 lakhs as penalty, we can interfere into it and we can ask the bank that settle the amount between. Yes.
My lord, time is given.
Your lordship,
What
can
time?
it?
Ask your junior, he will tell you. Yes.
Your lordship, can it be 31st? of
I'll
May?
be saying.
Your lordship, can it be 31st of May?
31st of May.
First of all,
For admission, item 14.
Well, in the meantime, no auction sale should be stayed, my lord.
We have not issued any sale notice.
Initially, it was stayed. Must have been.
Yes,
May it please your lordship. Lordship, I was the L1 bidder in a tender process for garbage collection and disposal, my lord, under the railways. My lord, the writ petitioner was the L5 bidder. My lord, the contention of the writ petitioner was that I did not have the pollution certificate.
that is what the finding of the learned single judge.
My lord, there is a difference of about 22 lakh. The work was of 56 lakh, my lord. My lord.
For the,
My lord. But there were certain aspects, my lord. The writ petitioner himself did not have that certificate. If my lord comes, if
so again, the learned single, what the learned single judge is ultimately directed.
my lord,
That this setting aside where the contract is made, are required to revisit the
Revisit.
tender process, that's all.
my lord,
They have not granted it to the respondent L5.
my lord, my lord. But my lord,
If there is a violation and clear-cut violation of the condition of the tender, how
My-
can the tender?
my lord, in fact, before the last date, I had applied for the certificate, my lord, and it was granted before the work, before the evaluation, my lord.
Admittedly, you have submitted after the last date of submission of tender.
That is true, my lord. That
And,
is true.
There is a specific condition in the tender itself that no document can be accepted after the last day.
My lord, that is there. But the railways themselves, my lord, they had granted us time, and my lord, they had taken into consideration, my lord.
That's the whole thing, whether the railways can grant time or not. That's why they should do Article 14. That's why. See. Set terms and conditions. You have to adhere to it. I mean, regulatory is. Is there any stay?
No, my lord, it has come for the first time.
Now, who is operating the contract?
My lord, the railways, my lord,
The railways are-
my lord, yes, my lord, the railways. My
On
lord,
their
in
own-
fact, my lord, I've just got the instruction now, my lord, that a subsequent tender process has been floated, my lord,
Then what will
my lord. My,
Okay. The learned single judge, while allowing the writ petition and setting aside the letter of acceptance dated 13/11/2021, comma, issued in favor of the appellant, has directed the respondent number 3, directed the NF railway authorities to revisit the tender process initiated by the NIT dated 7/10/2022, and to bring the said tender process to its logical conclusion in terms of logical conclusions in terms of the observations made in the impugned order. Which when it concept of the appellant has submitted that the railways have already issued has already proceed with the tender process as per the direction given by the learned single judge.
Fresh NIT.
A fresh NIT.
Fresh NIT.
The railway has issued a fresh NIT. The NF railway has issued fresh NIT. In relation to the work for which the earlier NIT was issued. In view of the fact that fresh NIT has already been issued by the railways, NF railways. We are not inclined to interfere this, in this appeal. The same is dismissed.
Deeply obliged.
Item 15.
So this appeal has come for the first time, Lord. Similar appeal has been admitted, Lord.
Give the,
I have to.
you are appealing for the sole respondent.
My lord, sole respondent, my lord, my submission at this meeting, let the matter come up together, my lord.
Yeah.
If other matter is there, my lord, lordship take the date.
Concept of the, Mr. D. Nath, senior advocate, senior government advocate, Assam has submitted the writ appeals involving, many writ appeals involving identical issue has already been admitted by this court. Full stop. Admit. The Mr. Swain put an appearance on behalf of the respondent number one.
Mal.
Hence, no need to issue notice. No need to issue formal notice to the respondent number, sole respondent.
My lord.
Lordship.
List after 4 weeks along with writ appeal number 50 of the 2024 or list along with, list along with 50, the 4 weeks, 50 of the 2024.
Mal.
And connected writ appeal also, my lord.
And the other connected writ appeals.
Lordship.
Item 16.
Make. Judge. This was the case of a nurse. I was just arguing just before the Bihu holidays, my lord. Who
The
challenged,
last occasion, Mr. Mahanta, you sought, Mr. Borbara, you sought time to obtain instructions from the,
I have got the instruction, my lord. This nurse, she says, I have preferred a writ appeal and I have full confidence on the judiciary.
yeah, that's right, but confidence is going to shake. We have to make certain observations on the charges, and if once we give this observation that the charges are clear and not ambiguous,
Ultimately,
then ultimately you will.
ultimately, it will be your lordship's prerogative. But I must discharge my duties, my lord, by saying a few things only.
You
Last
argued
occasion.
at length the last occasion.
Yes, my lord. My lord, there are two types of situations in a case where the charges are non-specific and vague. There can be two types of situations before your lordships. First, to allow the proceeding on such charges to go ahead. And when on conclusion of the proceeding, the delinquent challenge is the same before your lordship in the second round of litigation, then your lordship sets aside on the ground that the charges themselves were vague and non-specific. And most of the cases are like that. In only there are cases few and far between where proceeding itself has been challenged by courts of law. This is the second, like Anand Kulkarni's case, to hold that the delinquent must not be subject to the ordeal and hazard of a disciplinary proceeding based on non-specific and vague charges. So such judicial intervention may be few and far between, but in a given case, I respectfully submit, why not? Incremental case too late for some judgment.
Yes.
No, my lord. When a writ court can hold that the charges are non-specific and vague, The answer would be,
Only when the court is of the view that the charges are
yes,
ambiguous,
yes.
then
Yeah.
only it can help.
The answer is, my lord, and as is seen from various Supreme Court judgments, when from the article of charges along with the list of documents furnished to the delinquent, it is apparent that the charges are vague and non-specific, and it is not possible for the delinquent to defend it. That's where the charges on their face are non-specific and vague. And there cannot be a proposition to wait and watch if evidence in the proceeding can make the specific charges, non-specific charges specific. Prejudice is already caused. The moment I was asked to show cause some vague charges, the prejudice, it's not possible to defend vague charges and reply to the vague charges. The prejudice is already caused. I will invite your lordship to keep that in mind. Now, my lord, I was also submitting that day that hostility and malice was writ large right from day one. Well, hostility and malice, these are the words easier said than shown to have been really done. I'll try to show it. How? Day one. Lordship, what happened immediately after issuance of the so-called notice, and when I challenged, the authorities withheld my increments. Meaning thereby, so withholding of increment is one mode of imposition of penalty. Meaning thereby that they, even before conclusion of the inquiry proceeding, they imposed the penalty of increment cut, and I had to approach, and this honorable court, my lord, Lion Single Judge, had to intervene. Lordship may kindly turn to that.
That relief has already been granted by the learned single judge.
Yes.
Then
Yes. That's why I'm showing you how malice and hostile they were right from the very beginning. Lordship may kindly have a look at that judgment, paragraph 5 and 6. The respondents have been entirely up against me from the very beginning, my lord. That's what has been my apprehension, and which proved to be wrong, right? Paragraph 5, my lord. However, from the facts pleaded available before this court, it is seen that notwithstanding the period of absence without leave alleged against the lead petitioner, which is subject matter of the disciplinary proceedings, petitioner otherwise became eligible for her increment in terms of the relevant office memorandum. Such position, in fact, is not disputed by the learned counsel appearing for respondents. If that be so, then unless there is a specific order passed by the authorities giving reason for withholding of increment, mere pendency of a disciplinary proceeding and or pendency of any matter challenging the said disciplinary proceeding before court of law cannot be accepted to be a valid ground for denial of the increment payable to the petitioner. Next paragraph, Lordship. Under such circumstances, the denial of increment of the petitioner cannot be sustained, as no provision of law or procedure has been brought to the notice of the court, empowering the respondent authorities for withholding an increment solely on the ground of pendency of a disciplinary proceeding and or pendency of a proceeding before this court involving the said disciplinary proceeding. Communication dated so-and-so issued to the petitioner is therefore set aside. By this communication, I was said that, well, you have a disciplinary proceeding, we are not going to pay you increments for 3 consecutive years. The authorities are directed to release the increments payable to the petitioner as per law without any further delay. Pendency of disciplinary proceedings cannot be considered to be a valid ground to withhold the increment payable to the petitioner until disciplinary authority on the valid reasons assess withholding, and therefore respondents were directed. So this is what has been meted out to me. Now, I'd refer to my lord the impugned judgment. In fact, learned single judge
yes,
I'll refer to my lord impugned learned single judge judgment here, my lord. 2 of the paragraphs. In fact, learned single judge did not dismiss the petition or took into account, my lord, the ratios of Anand Kulkarni's and Suresh Chakraborty's case, my lord. Well, lordship may kindly turn to paragraph 18 of the judgment at page 186. paragraph 18, 186.
Yes.
In Anand Kulkarni, Apex Court was examining the findings arrived at by the tribunal as well by the High Court, where the tribunal and the single bench of the High Court arrived at a conclusion that charges were vague and non-specific and declined to permit the authorities concerned to proceed de novo. That was a de novo inquiry, in order to save the employee from harassment and humiliation. Said judgment was also upheld by the division bench of the High Court and however permitted the authorities to proceed with the inquiry afresh. Tribunal, my lord, didn't allow to proceed. Single judge didn't allow to proceed. Division bench allowed to proceed. And then Supreme Court preferred this step. The Apex Court examined the charges, paragraph 19, framed in detail and arrived at a conclusion that none of the charges are specific and precise. It was held that the charges have not been accompanied by a statement of allegations or any details thereof, and it was therefore not permissible for the respondents, namely to hold an inquiry on the charges. And on these findings, Apex Court altered the order of the division bench of the High Court to the extent and interfered with the findings of the division bench to conduct or hold a fresh inquiry on the charges. Apex Court, under consideration of the facts, my lord, the other case it has referred, Surat Chakraborty, in which my lord Anand Kulkarni was also, by this judgment was discussed. This is Surat Chakraborty. This court held that it is not permissible to hold an inquiry on vague charges, as the same do not give a clear picture to the delinquent to make out an effective defense, as he will be unaware of the exact nature of the allegations against him and what kind of defense he should put up for rebuttal thereof. Court observed, grounds on which it is proposed to take action have to be reduced to the form of a definite charge or charges which have to be communicated to the person charged, together with a statement of allegations on which his charge is based and other circumstances which it is proposed to be taken into consideration. In passing, orders has to be stated. This rule embodies a principle which is one of the specific contents of a reasonable or adequate opportunity of defending. If a person is not told clearly and definitely what allegations are on which the charges preferred against him are founded, he cannot possibly, by projecting his own imagination, discover all the facts and circumstances that may be in the contemplation of the authorities.
Which
That-
para you are referring to?
My lord, I am reading at page 187, 188.
Internal para,
Yes, my lord.
judgment,
Yes, single judgment, I am reading, my lord. Page 187 and 1. Where my lord Surat Chakraborty, Lane Single judge discussed Surat Chakraborty's case, my lord. (187) as a lordship. Para 188. If a person is not told clearly and definitely what allegations are on,
you are reading these quotations.
yes,
Inquiry on big charges.
yes, right.
Yes.
Look, if a person is not told clearly and definitely what allegations are on which the charges preferred against him are founded, he cannot possibly, by projecting his own imagination, discover all the facts and circumstances that may be in the contemplation of the authorities to be established against him. Where the charge sheet is accompanied by a statement of facts and the allegations are not specific in the charge sheet but are crystal clear from the statements in such a situation that both constitute the same document, it cannot be held that as the charges were not specific, definite and clear, the inquiry stood vitiated. Thus, nowhere should a delinquent be served a charge sheet without providing him a clear, specific, and definite description of the charge against him. When statement of allegations are not served with the charge sheet, the inquiry stands vitiated as having been conducted in violation. The evidence adduced should not be perfunctory, even if the delinquent doesn't take the defense or make a protest that charges are not vague. Charges are vague. It is not required for him to say. He can come to the writ court and say. That doesn't save the inquiry from being vitiated, for the reason that there must be fair play in action, particularly in respect of order involving adverse panel. What is required to be examined is whether the delinquent knew the nature of accusation, which form the basis of charges, and no inquiry can be sustained on vague charges. Then your lordship may come to paragraph 27, what the learned single judge then said. Having discussed all these things, at page 191, paragraph 26 of the impugned judgment, the arguments made by learned counsel that charges in the charge sheet are vague and non-specific, and thereby petitioner cannot be expected to put up a clear defense, cannot be adjudicated at this stage. There I am. I was inviting his lordship to adjudicate up, and he declined, my lord. And in my humble submission, prima facie, in the absence of any final order passed in the disciplinary proceeding as on date due to operation of the interim order, no such order in the course of disciplinary proceeding till it was suspended by so and so. Order was suspended. Has also been brought to the notice of the court, which in the opinion of the can give rise to a cause of action. The vagueness of the charges and the additionally, my lord, second so-called afterthought charges level were, my lord, good enough to exercise jurisdiction under 226. Then, my lord, his lordship said, and one more thing, the charge number 2, the ingredients of the civil rule 20, service rule 20 were absent, and I drew your attention to both your lordships to that, my lord. No discussion was done. Then 27, under such circumstances, this court cannot find force in the submissions made by the counsel for the petitioner to invoke writ jurisdiction for interference of the proceedings at this stage. Such view of the court, however, should not be understood to have overlooked the apprehension expressed by the petitioner that charges are non-specific and does not provide an opportunity of a specific defense required to be put up by the petitioner. As it has been held that disciplinary proceedings have not yet been culminated into any findings, either by the inquiry officer or by the disciplinary authority, this court refrains from returning any finding at this stage as to whether charges levied against are definite or specific. My lord, I respectfully submit that this is refusal to exercise jurisdiction or adjudication on vagueness and infirmities of the charges. And that is where I am begging your lordship's intervention. As to whether charges leveled against petitioner definite and deprives the petitioner of putting, I mean, it is a turmoil of undergoing the hazards of a penalty on vague charges for 2-3 years. Why? Deprive the petitioner of putting up specific defense. Yes, I was deprived. This court is of the considered 193, page 190. Considered view that ends of justice should be met if the petitioner is given liberty to raise the issue before the inquiry officer or disciplinary authority. Again, my lord, the first limit. Without, my lord, giving a finding as regards the vagueness and on the basis of the pleadings and the documents. No opportunity of perusal documents stated to be relied upon by the inquiry officer for the purpose of was afforded to the petitioner, and then petition was disposed of. The petitioner will be granted every opportunity and all. So learned single judge in a way neither rejected my prayer nor accepted my prayer.
Yes.
And my lord, that day I was, my lord, referring to some manipulation of, my lord, the documents that were supplied to me showing with regard to the first charge, unauthorized absence for 8-10 days during the pandemic period, my lord. Page 96 is the chart, my lord. Page 96, lordship may have, I drew your lordship's attention that day, my lord. So this was, along with the show-cause notice, this was served to me. Page 96, kindly have a look at this page. This is the duty roster. This is not my document. Page 96.
Yes.
This is their document, my lord. They have supplied it to me, and this is the, my lord, also they have appended to their affidavit filed before this court. Kindly have a look. Top is my name, Viola Burua. Again, none other nurses. There were cut marks and scratches and overrating. And this is a clear case of manipulation.
What?
My lord, have a look. Lordship is getting page 96.
Yes,
Lordship, kindly say top left side, left-hand side, it is my name, Viola Borua.
yes.
Against my name, from 26 March to 5th of April, it is written, my lord, and sketches, blackish. I am not the custodian of document, this document. They are the custodian. They supplied it like this. And Lordship, kindly see, against the name of no other nurses, such scratching and cuttings are there.
So what manipulation is there?
My lord, these are scores through, my lord, these are blacklist, my lord, these were cut, this is the way they have supplied this document. Against my name, this is there. Against none other names, my lord. There are scotching and cuttings and blacking of the entries. And I am not the custodian of this document. They supplied it like this. So it has a similar relation to the, my lord, hostility and malice and, my lord, even the manipulation of records. And making the allegations against me, my lord. And in this case, first there were two charges about these things, and secondly, in political exerting political influence on the ministry, which is absolutely not correct, because I sent a copy at page given. That day I drew your attention to your lordship. During the Kent, I was just applying for a car pass, which page 74, my lord. No, page 79.
Yes.
Then this they say, prima facie. From page 75, my lord, all electronic conversations, me praying for a pass, because I was an outsider, campus outsider. 3 kilometers I have to travel to the hospital during those days to attend my duties. It was not possible. I sought for a car pass to the name of my husband. That was declined, and ultimately, after all this, there was a Union Ministry, my lord, opened a website at that time, my lord. Page 79. I gave copy to everything, and then one copy was given.
Mr. Borgura, your principal argument is that the charges are vague, and therefore you are prejudiced as you have not been able to defend your case properly. This is what we are not going to look into the
Maybe
truthfulness of the charges at this stage. Nah.
only one thing I am saying, by this copy I sent, along with the director, I sent a Ministry of Health and Family.
Maybe that is
Right.
what the disciplinary.
And
If
there-
he holds that these charges are vague, everything will go. If he hold otherwise, then you prove your case before the disciplinary authority. That's all.
Ultimately, that will be your lordship. At the beginning, I told your lordship.
Yes,
But
that's right.
this,
So your principal
this by
argument,
itself,
your principal argument is the charges are vague, or therefore they can't proceed against you. on the
and
basis
number
of the
two,
charges. That's
and
all.
number two, the charge number two, the essential ingredients of
Oh, that is-
misconduct are missing, because
that is the included in the argument. The charges are vague.
Yeah.
That's all.
and hardly, my lord, first so-called I replied, 2 charges were there. In the second charges, they added some other charges, which is not open to them, my lord.
That's
That could have been a different disciplinary proceeding. In one's lifetime, I may face 2 different proceedings for 2 different charges.
yes.
One charge you open up, I reply, then you add some other charges, and that is not permissible.
We
my
have
lord. That
understood
was-
your arguments. Yes, yes, Mr. Now, concept of the respondent voting.
No cause of action arose for opposing dishonorable court because we have initiated the DP, but because of this litigation before this
We
court,
are ordered by this court, you have not been able to conclude it.
admittedly, she was absent for the period 26.
What's
did
your
not-
response to their argument that the charges are vague?
Not big, my lord, they stated that these documents are duty roster. During absent period, the medical superintendent forwarded the a copy of the Xerox copy of the duty roster by highlighting over the absent period of the petition. It is
That is why it is a blackish color,
Only highlighter was made there on.
highlighting dye. And thereafter, so-called notice was issued. My lord, the inquiry appellant relied upon the memorandum during this period, during COVID period. He did not attend the duty as a staff nurse. And 67, my lord, it is the office memorandum issued by the government of India for restricting.
So what is your argument ultimately that the charges are vague or not?
My lord, Honorable Supreme Court said that it will come up later on, my lord.
Which is the judgment of the
Judgment Supreme Court says that para 10, my lord. 10, 11, 12. So that is one to one.
That the learned single judge has already placed reliance on. This is what the judgment.
Yes, my lord, there's Honorable Supreme Court said.
Any other judgment?
Other judgment is Upendra Singh, my lord. Union of India and others. That
Which para you are referring to?
referring to my lord, para 3, my lord. Para 3. Para 13 of citation of Union of India and others by Upendra Singh. It, 1919 were reported in 1994 SSC 357.
Yes.
And here, my lord, the Supreme Court says that the court is not ought not interfere with the charge sheet, my lord.
In this judgment?
Yes, my lord, it is a
Upendra Singh judgment. Union of India versus Upendra Singh.
yes, Secretary Ministry of Defense and others reported in
Prabhas Chandra Mirda.
first one, my lord. 2012 reported in 2012 11 SC.
Yes.
567.
That's all.
Para 4, my lord.
That's all.
Para 10, my lord.
Then we'll read this. That's all. Close
10, 11, and 12, my lord.
Close for orders.
And another is
Yes.
Next, item 17 to 19.
Next is your lawsuits. In the all these three cases lawsuit, all the magistrates who were entrusted to conduct the physical possession lawsuit transfer to other place lawsuit. They have sent letter lawsuit due to the code of conduct. Now they are going to get another magistrate lawsuit. Kindly see my instruction.
They are going to appoint another magistrate.
Yes, lawsuit.
Why?
Other who were entrusted, they were transferred to other district lawsuit.
When they were transferred,
That has not mentioned, Lordship.
then you please explain it. The orders were there in favor of the bank since long.
Lordship, then, in item number
The
9.
magistrate are the magistrates are not, this executive magistrates are not taking any steps, then what's the meaning of this?
And Lordship, in respondent number item number 19, respondent number 4, give application before the authority. Yes, some part payment has been made.
Yes,
May I?
yes. Respondent number 4 in.
In item number 19.
19.
My lordship, if I be able to say is actually, this read is technically not correct actually. This read is technically not correct, whatever the orders may come, but this read is technically not correct. First, if your lordship may permit the order actually, the order is there, enclosed is in page number 46.
Yes,
I will try to explain why this is not technically right actually. In the, this is the order dated 20/12/2022.
yes.
Okay. Now what happened, if I come to the 6th paragraph, it has been written, therefore, I, Sri Pallav Gopal Jha, IAS so and so, of the power conferred upon me under section 19 of SARFAESI Act 2002, do hereby authorize me the Krishnishka Bora, ACS, Assistant Commissioner and Executive Commissioner, Kamrup Metro. Means she has been entrusted for taking the physical position. She is the executive magistrate. Coming to the next line, for the purpose of securing compliance with the order under section 14 of SARFAESI Act and Rule 2002, I also authorize the magistrate to take cost to be used such forces as may in the opinion be necessary. Now the main line is that the magistrate may fix the date in consultation with the bank authority and keep close liaison with the police, bank authorities and take appropriate steps as per provisions of law. What happened is that in this case, this particular executive magistrate was cancelled. I'm sorry, she was transferred. Now this order is invalid. So what the bank usually does, what the routine is that they have to redate this, means they have to reapply for these things. So another magistrate names will be applied. This is the procedure.
They'll pass an order. What's wrong in that?
Okay, so this is what I am.
The grievance is this, that despite issuance of the direction by the district, commissioner, the district magistrate, the executive magistrates are not taking any action.
In my case, they are not supposed to also. I will explain why.
Who are not supposed to?
Yes.
Why?
This,
Because she has been transferred.
No, there are other causes actually. If I come to point number 2, actually, what the bank is,
They'll inform him that they are not supposed to take any action.
no, what happened actually in my affidavit in opposition. In my affidavit in opposition, in page number 91, the district magistrate has himself called both the parties, the bank and me, to settle before this one. It was on
District magistrate authority. What is the authority with the district magistrate to ask the borrower as well as the bank to settle their dispute on between them? What is the district?
My lords, I will not come into the authority, but this is the letter which has been given to me.
What is the authority? What is the sanctity of this letter? How
So
the district magistrate can even
That means
ask?
the district magistrate should not have given this one, should not have given, but they have
He's bound
given.
to give. He's bound to give.
Now,
Whenever any such application is filed, the only course for him to issue such directive. That's all.
now the thing is that they have called on 8/2/2022. Now all paid, all paid. Lordship, my contention is that payment has been done in my case.
Then technically, if the payment is done, they will not insist for taking position of the.
They have taken insist, they have taken insist, they have taken, that's why,
They have
that's why
taken the position.
they want to take the position after payment as per whatever the bank.
That's why you approach the DRT, that you have already made the payment and they are going to take position, that's all.
Your lordship, I will, but the thing is that what I want to pronounce is that this writ is not in the clean hands. And apart from that, as per the order dated of this honorable court,
Their only grievance of the bank is this, that despite the district magistrate has passed certain directions to the executive magistrate to take the position of the land, they are not acting. How you are agreed by them? They are not acting, certainly. they are not
lordship,
acting.
in this case also, the order dated of this honorable court in 1/3/2024, at this thing is that the order dated was 24/7/2023, wherein there is no such order as such.
Okay, fine, we have committed a mistake, we'll clear it now. Okay? We have committed a mistake and we'll clear it. Okay. These writ petitions are essentially filed on behalf of the petitioner banks raising a grievance that despite specific orders issued by the concerned district magistrates under section 14 of the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act and Rules 2022. 2002 to take possession of such as to take possession of the mortgage assets and documents relating thereto, and to take necessary steps in consultation with the bank authorities. The concerned executive magistrates have failed to take any steps for the purpose of taking possession of such assets and documents. Full stop. It is contended that the orders of this effect were passed by the district magistrates way back in December 2022 and subsequently, but till date, no action is taken by the executive magistrates. Full stop. Pursuant to the direction given by this court, Mrs. R.B. Bora, GA Assam, has submitted that the executive magistrates have failed to carry out the orders passed by the concerned district magistrate on account of their transfer from the concerned districts. It is also informed that since now the model code of conduct is in operation, the operation, fresh orders, fresh instructions would be issued to the executive magistrates to comply with the orders passed by the concerned district magistrates after the model code is after model code of conduct is over. Full stop. Taking into consideration the above submissions made on behalf of Mrs. Bora, we deem it appropriate to list this matter on 7th of June. On that day, fresh instructions, fresh progress report be filed on behalf of Mrs. Bora.
My lords, leave may be granted to me so that I can approach the DRT. Otherwise, the limitation
Where
is
the
over.
question of leave? Where is the question of leave? This is your statutory right.
No. The thing is that if the order is not stated as such, then the limitation will apply at DRT of the 45 days and I will not be allowed to go. That is,
We can't, if the.
Banks now, one same bank.
see, if only the if you apply.
Your lordship, your lordship wanted district magistrate order in item 19 is of 2022, other two are is of 2023.
Subsequent dates, but
Yes, sir.
that's why only written it.
Yes, sir.
Item 20 and 21.
All right.
Wait, your lordship. Well, item number 20, lordship, the matter came up last week, lordship. There was a unfortunate delay of 1 day, and that was not condoned, lordship.
Yes.
Lordship, that they are submitted, that is in view of the judgment of the Honorable Apex Court in Suomoto, 3 of 20, that is covered. I am not disputing this.
Then
That's my lord, my son, another case.
Lordship, there is another case, lordship, but that is not related to this case at all, lordship. I am in that case, lordship, I am challenging the order of the district magistrate, lordship.
district magistrate, without approaching the DRT.
That is the,
At all.
Lordship, I'll satisfy your lordship.
no, lordship, if lordship,
Okay, first of all, we'll pass this order in this petition and then we'll hear that.
lordship, on the other case, lordship, well, I'll satisfy your lordship. Because on some other day, lordship, because
Not other. You can't have both the things in here.
lordship, then I'll satisfy.
Okay, this writ petition is
The item 20, item 20.
20 bad, let's see. And this writ petition is filed by being included with the order that 2024 passed by the Debt Recovery Tribunal whereby the application filed by the petitioner under section 7 of the Securitization Act has been dismissed on the ground of delay of 1 day in filing the said application to stop. Submit concept of the petitioner has submitted that the DRT has grossly erred in not condoning the delay of 1 day in filing the application under section 17 before it is contended that as per the order passed by the Honorable Supreme Court in miscellaneous application number 21 of 22, in miscellaneous application number 665 of 2021, in suo motu writ petition C number 3 of 2020, in recognizance for extension of limitation with other miscellaneous applications, the delay of 1 day is liable to be condoned. It is contended that the limitation for filing the application under section 17 was expired on which date it was expired?
On the date of filing, lordship,
On the day, which was the date of filing?
lordship, I'm coming. On 15/10/2020, Lord.
On 15/10/2022.
2020 law.
2020. 15/10/2020.
15/10/2020. However, the limitation for filing any proceedings before any court under any general or special law was extended by the Honorable Supreme Court from 15/3/2020 to 28/2/2022. It is contended that the DRT, without taking note of the above fact, has illegally rejected the application filed by the petitioner under section 17 of the Securitization Act, treating it as barred by limitation. Now, the concept of the respondent bank is not in position to dispute the fact that as per the order passed by the Honorable Apex Court in so and so case, recognizance or extension of limitation dated January 10, 2022. Or the limitation in filing in initiating any judicial proceedings before a court under any general or special law was extended up to 28/2/2022. Taking into consideration the above fact, as well as taking into consideration the above fact and the and the directions given by this by the Honorable Apex Court in recognizance of extension of limitation supra. We are of the view that the learned DRT has erred in rejecting the erred in dismissing the application filed on behalf of the petitioner under section 17 of the Act of the Securitization Act while treating it as time barred. Hence, the order dated 26/2/2024 passed by the Debt Recovery Tribunal Guwahati in IA number 196/2020 is set aside. The DRT is directed to consider and decide the application filed by the applicant under by the petitioner under section 17 of the Securitization Act while treating it within limitation on merits in accordance with these observations the petition is disposed of. Now come to the next.
Highly obliged, Lordship. Now, Lordship, this is the third round of litigation, Lordship. This Lordship 7020 of 2023. This is the third round of litigation, Lordship. First round of litigation came in the year 2020. The second round of litigation came in the year 2021. And on 2023, the third round of litigation.
You are reviewed by which order?
Lordship, I'm coming to that, Lordship. All these while, Lordship, the writ petitions, we have challenged the order under section 14. This is not the first time that section 14 has been issued. Now, Lordship, I'm coming to that, Lordship, in the impugned order, Lordship, would find. Lordship may come to annexure 22, Lordship. In page number 141. Now, Lordship, this is an order passed by the additional
page
141, Lordship.
Yes.
Now, Lordship, that is the impugned order, Lordship. Now, date may be seen, Lordship. The date is 2011-2023, Lordship. Additional District Magistrate, Kamrup Metro, 2011-2023. Now, Lordship may read the order. Seen and perused the letter received by the authorized officer, State Bank of India, so-and-so, while later dated so-and-so dated 5/12/2023. under section 14 of the Securitization Act against the borrower Sri Durlabh Sharma.
Wrong mentioning of date.
Now, Lordship, I'm just coming to that. Now, Lordship, I'm coming to that. Now, Lordship has to see, Lordship, what has been happening throughout last 3 years, Lordship.
But saying you are approaching the court on the ground of COVID and the court has granted stay, your application under section 17 is pending, you are seeking adjournment in that application. This is what happening.
No,
And
Lordship,
nothing else.
no, Lordship may kindly see, Lordship may, I have annexed it, Lordship. I have seen the document. Lordship may kindly see what has happened in page number 128.
Yes.
Now, this is the limitation act, the limitation application which I have filed. Now, after that, Lordship, subsequently in page number 135, how the proceeding has been happening, Lordship may kindly see this.
Challenge it before the appellate tribunal.
No, I'm not on that, Lordship.
Appellate
I
tribunal.
absolutely bow down to your Lordship's jurisdiction, and I also understand the Supreme Court decisions involved in this regard, Lordship.
Then why?
But what I'm on, Lordship, is that since today, Lordship has Lordship has allowed the delay application. Now because till in my writ petition, I have sought time till June 2024 for making the payments, Lordship.
Go approach the bank authorities and nothing else.
And
You
what,
are not supposed to give any time.
no, only thing is that, Lordship, no coercive action until I file an appropriate application before the DRT, Lordship.
We are not at all entertaining this, treating this writ petition as not maintainable. You can't ask for an interim order.
Lordship, may I submit? Just one submission. Lordship, so for the previous writ application is concerned, I just I'm saying the factual. Just, I'll draw your lordship just a factual aspect. This is the writ application 210. After which they have approached the DRT. Now the Lord Debts Recovery Tribunal has granted them interim stay.
Yeah.
Besides, they are doing a condonation petition. The condition was they have to deposit certain amount, which they failed.
No, we have, Lordship.
Just, that is the order.
Yes.
That is the, I can produce. They have failed. They have sought for extension of time. 1 year time was given
By the.
by the DRT. Again, in 2021, they have prayed for time. Thereafter, the DRT has given a specific order that within certain time you pay the amount of 30%, otherwise the bank is at liberty to proceed. That time also, the interim order was given pursuant to a district magistrate order, similar sort of order in the year 2020. They have failed, even in 2021. After which, since they have failed, the stay order did not continue. So that is the crux of the matter. Now, Lordship, their writ petition, just, I'm telling your Lordship, their writ petition. I'll take your Lordship to the paragraph. Why they have filed this writ petition is due to the pendency of this case of the delay which has been condoned in paragraph 32. Of the writ petition, page 24.
Yes.
The petitioner backstated that the application under section 17 of the SURFACE Act, being DRT diary number so and so and meets condonation number so and so, is pending adjudication before the learned Debts Recovery Tribunal Guwahati. That the hearing on the condonation petition of the application was conducted several times, and the respondent bank filed written objection in the month of so and so. Then says the matter was partly heard, however, no order has been given. Thereafter, your Lordship will take. That is why they have passed. Now, Lordship, I'll take your Lordship to the relevant portion, paragraph 42 at page 30.
Yes.
The petitioner backstated that the petitioner is paralyzed and in bad financial state. The petitioner is pursuing the application under section 17 of the SURFACE Act before the learned DRT, and as such, the petitioner has no other alternative to beg before this honorable court time till June 2024 to clear all dues. The petitioner shall, if required, deposit post-dated checks in this regard. And that is also in the prayer.
Yes, Lordship, I'm not saying that, I'm not denying that, Lordship.
So that-
Lordship may kindly see, no, Lordship may
That
kindly
is
see,
his
that
prayer.
is,
So now your,
Lordship, my,
now your DRT, your application is already revived.
my lord.
Go and that.
Yes, my lord, my lord, may kindly see one aspect, Lordship, in para number 41. Lordship.
DRT is fully competent.
Yes,
to grant
Lordship.
you time and what.
Exactly, Lordship. Lordship may just see 141, why this has happened, Lordship.
Yes.
Actually, Lordship, this is not the only case. They have also filed an OA, Lordship.
Yes.
And that
the
has been
original
allowed
application
against
cannot
my,
validate, and the original application is
against my
disposed of,
favor.
recovery
Now,
certificate has been given.
Now, since there is a order running against me, and there is a recovery proceeding against me. Now, I am taxed double. Now, one side.
Seek stay from the DRT.
Yes, the only thing, Lordship. Yes, Lordship.
Your application.
Yes, Lordship. The only thing is that, Lordship, till June, since I have asked for till June, till then, Lordship, no course of action.
Ask the, that.
Or until the
have
day I
already
approach that
revived
DRT,
your
Lordship. That can be
You
given.
have already revived your appeal.
Yes, Lordship.
That application before they.
Yes, Lordship. Then Lordship may kindly fix a date on that day, Lordship. That can be done.
Where?
Before the DRT. Before the DRT. Yes, Lordship.
Take it out.
Lordship may kindly fix the date before the DRT.
Use the order of this court which we have passed in the earlier
Lordship,
petition. before the
otherwise what
DRT,
will happen, Lordship? Otherwise, the bank authorities will go and try to revive the.
So now you want order on merit or wants to withdraw?
No, Lordship, only thing is that only that a date may be fixed when I'll approach, Lordship. That
is not. You approve the DRT.
Lordship.
You want to withdraw or we pass an order?
Lordship,
In view of the order passed in the other.
yes, Lordship, that in view of the order passed in this case, Lordship, I may
You
be
want to
withdraw and with the liberty to approach the DRT.
You have already approached the DRT, your application is revived there. Where is the question of liberty again granted?
I understand.
Pending tha na.
It is already.
He wants to withdraw why?
In view of the order passed today in writ petition number 2114/2024, whereby the proceedings initiated by the petitioner under section 17 of the Securitization Act before the DRT are revived. The petitioner has submitted and he wants to withdraw this writ petition with liberty to pray before the DRT to get the application under section 17 be listed at an early date and be disposed of expeditiously. Dismissed with liberty as prayed for.
Item 22.
going to repeal. Second, they said it is not a compulsory registration. On the end, compulsory is not, the registration is not compulsory. And number three, it encourage child marriages. And there is no mechanism for check and balances. So on these three grounds, it has been placed before the governor. Governor by an ordinance on 15th of March 2024 has decided to promulgate the ordinance. Now I am before this honorable court. Now it's very limited. It's like an act. Now on very limited ground of judicial review. On the ground of judicial, maybe on a fraud on power or minor on an oblique motive. There's a test before your lordship.
The oblique motive.
Now
What's the fraud?
No, there is no fraud.
Yes.
That's why two grounds I am saying. There can be a fraud on power, there can be judicial review, or there can be an oblique motive. First, there cannot be first ground on fraud on power. It is an oblique motive. Now that's the test where I have to satisfy your lordship why there is oblique motive. Before that, my lord, governor doesn't exercise his own mind. It is on the aid and advice of the Council of Ministers under 163. That's cabinet decision which has been taken. But what is the emergency that exists?
The governor is supposed to act on the advice of the council.
That's what I'm saying, on the aid and advice of the Council of Ministers. But what is most important, that is one aspect of the matter. Why it was so necessary for the governor? Emergency that arose for issuing this ordinance. Because that's a 1935 act. I'll satisfy your lordship. I'll satisfy your lordship by showing the judgment of the Supreme Court of 2007, that Bihar case. That's a constitutional bench judgment. I'll show it, my lord, before your lordship.
If the government is of the opinion that this promotes child marriages, and if it is there is no mechanism to check.
There is a mechanism. That's what I'm saying, my lord.
One reason.
No, I'm showing it before your lordship. There was a mechanism. There is a provision under that 1935 Act, Section 8.
Registration was compulsory.
Registration was compulsory because of judgment of the Supreme Court. 2010, there is a judgment, Sima versus so and so. They said irrespective, 2010, because all other religion, which may be Hindu, Muslim or Sikh, whoever, registration was not compulsory.
So
Thereafter,
after
the judgment, they made compulsory all. Now 2010, these 1935 in 2010, they amended and they inserted this particular clause, whereby it made.
Yes.
Mr. Das.
Yes.
In India, we follow the Westminster model of governance, right? You know what it is. Now, these are activities essentially in the field of legislature. And ordinance is merely a stopgap arrangement, which has got an expiry date, which is 6 months.
6 months.
But essentially, it is a policy decision of the government vetted through the cabinet, and governor merely acts on the aid and advice of the council.
That's right.
Now, the grounds to challenge an ordinance is akin to the ground to challenge a statute.
Absolutely correct.
Right.
Right.
And that is, we all know. Even yesterday, there was a judgment. Only two grounds are available: lack of competence,
yes,
and violation of fundamental rights. So, would you address the court?
No, yes, my lord. Like kindly see. Now, by repealing this particular, we are in limbo. We can't do anything. Where a registration will take place. Now, let us take from there is a Special Marriage Act. All the registration can be done with a Special Act on 1954. Absolutely, there is no problem. But for this, the law which is under Mohammedan law, can we go and register ourselves? No. There is a prohibition under Section 4. Now it has been limbo where, my lord, the marriage registration takes place. I'll put an example. Registration takes place prior to the repealing of the Act 15th 3/2024. Compulsory registration has been done. Today, there is a mutual divorce. Where I will go? There is no alternate registration which they have made. For a Muslim community, where they will go? It is a limbo. No alternate registration has been framed by them. So that's what I'm.
State, file your counter.
Lordship, may issue notice.
Are you not receipt of this writ petition?
Yes, my lord, I have.
Issue notice. Valid. Concept appearing for the, you are appearing for?
My lord, respondent number 1, 2, and 4. And my learned friend for the 3.
Respondent number 3. Issue notice, Mr. So put in appearance on behalf of the respondent number 1, 2, and 4. Mr. So is appearing on behalf of the respondent number 3. No formal notice is required to be issued. And counsel for the respondents are already in receipt of the copy of the writ petition. They may file their response to the writ petition by the next date of hearing. Put upon 22nd of July.
Mala, only prayer is there, my lord.
Yeah.
I know my limitation in ordinance. Only the government has to find an alternate mechanism. We can't do anything at the present moment.
Let us
So
find the
22nd of July will be, my lord, the humble prayer is being made, my lord. Suppose it can be fixed in somewhere in the month of May. I know myself.
No, my lord.
Mala, it is stalled. Entire, my lord, I can't.
My lord, they may register
Registration.
before the sub-registry everywhere. There is no bar, there is.
24th
What my learned friend is,
24th of June.
My lord, extra copy may be directed to be served.
my lord.
Extra
Will my learned friend is a sub-register. How can I go marriage which has taken place under marriage, the registration of 1935?
24th of June. Sir.
What?
24th of June. Yes. By reflecting list on so 21, reflecting the names of so.
June.
Item
Can it be
23.
somewhere in the month of May, my lord.
June. Okay.
May last,
In
my
fact,
lord.
May, we have already fixed many of the dates.
Somewhere, if it is not inconvenient to your lordship, my lord, June 1st.
That may be inconvenient.
June 1st, my lord. June 1st, my lord.
22nd of, we have already.
Mr. Sharma,
Yes.
please come up with instruction
Yes,
responding to this.
definitely.
In the interregnum, what is the
That's
legal
the,
framework?
yes, correct, my lord. That's the whole, my lord, I can't go and marriage under the Special Marriage Act also, my lord.
Yes.
Prohibited degree, my lord. That's the whole problem. My lord, they will have to come up with an alternate legislation, my lord.
Or at least issue a notification.
That's what the notification they can issue, my lord. Some alternate arrangement they can make.
That's why only, brother.
Otherwise,
already asked-
my lord, I would not have trouble, my lord. I know my limitation in this matter. But the problem is that there is no alternate legislation.
That's why.
We are
only
in so
asked them.
limbo, we can't do anything,
You
man.
asked them, right?
Will
Yes.
definitely come.
Yeah.
Immediately after the MCC.
Smile.
you can-
Can they, your lordship, reflect in the order? There's some alternate arrangement. They will, some order
We have
reflection
already
is there, my lord.
instructed them, will remember that.
That will be easier. If otherwise, any order path that becomes, my lord, easier for the government also.
Mr. Das, it can't be done while the MCC is in force, so it will roll into the first week of June. So therefore, the matter is, yes, we have
Yes.
already fixed it. Can't be helped, you have to wait.
Yes. Preparing for the.
Board of conduct process, election.
I'm deeply obliged. I'm deeply obliged.
Item number 23.
Question. May I please your lordship? This is an income tax appeal under section 260A.
This substantial question of law has already been framed.
Yes, my lord. The question of substantial question of law had already been framed by the earlier division bench.
And here this matter.
But only, I want to point out page 160.
One,
160.
Because the appeal was remanded on the prayer of the SCC. Remanded on the prayer of the SCC. Yes, sir.
My lord, there were two grounds of appeal.
160.
On one ground, they have remanded.
Let me
Yeah.
come. Paragraph 11, Lord. Before, as the here of the SCC has submitted the failed to look into the documents published before. Non document but before the CLP under the application is not made with single tender. Made it so. Partly. Why partly allowed? Actually, one question was decided and for another question because they failed to submit some document. That was their prayer. So that first issue is alive. That is there, but only for the second issue they have remanded the matter, but first issue is alive. Since they till here it since they while issuing notices to this court on 8/12/2023 has already framed substantial question of law and has passed interim order in favor of the appellant. Admit no need to issue notices, parties are already represented through counsel. List this matter for hearing in the month of July. Till disposal of the present appeal, the interim order passed by this court is made absolute.
My lord, there was a prayer for, the interim prayer was there.
It has been made absolute.
Item 26 to 30.
Was there. Thereafter, they have published the selection list also. Based on that gradation list, one selection list has been published. In that list also, our name is there.
Your name is?
Is there, is present in there. So as per that selection list, we are entitled to be promoted.
The promotion could not be granted since the reserve vacancies have not been
Yes, my lord.
specified. Now
Yes.
it has been specified, then consider.
Specified, my lordship. But my lordship, during pendency of this appeal, my lordship, several development has taken place.
What development?
My lordship, they have prepared another gradation list, my lordship, in the year 2022, my lordship. In that gradation list, it has not been prepared as per the guidelines. As per the guidelines, there is a committee, my lordship, district level committee, which has to prepare the gradation list. The district elementary education officer, on his own, he has prepared a gradation list without incorporating our names, my lordship. Thereafter, that gradation list has been challenged before a single bench, my lordship.
That is
And-
pending.
Yes, my lordship. So all the matters must say yes, because same subject matter, all the matters has been tagged
That
together.
is all. Writ petition number 4268/2022. With the prayer to issue a direction to the respondent state to undertake the process for promotion to the headmaster / headmistress of the provincialized ME/MEM/MV and senior basic schools of district of Alakand. Learned single judge has refused to interfere while observing that unless such posts are identified by the WPT and BC department for reserved categories in terms of the notification dated 2/3/2010, no appointment on the post of headmaster, headmistress of provincialized so and so ME, MEM and MB senior basic schools of district of Malagandi can be promotion.
No promotion.
No promotion to the post of can be given to the petitioners. Full stop. On instructions. Learned, on the last occasion, the council for the state of Assam was directed to clarify that why the education department has failed to specify the vacancies for the reserved category for the post of headmaster / headmistress of provincialized ME, MEM, MV and senior basic school of district of Alakand. Mr. Majumdar, learned advocate appearing for Mr. NG Khatania, counsel appearing for the elementary education, Department of Elementary Education, Assam has submitted that by the order dated 23rd of April 2024, the reserved posts of headmasters for MEM, ME and so and so senior basic schools has already been specified. A copy of the letter of this effect, a copy of the letter issued by the Director Elementary Education Assam is placed on record as per the said letter.
The projection to the projection material is posted reserved in the process.
As per the said letter, the projection of the reserved post is given as follows. Yes, pencil to pencil. in view of the fact that now the government has already specified the vacancies for the reserve categories for the post of the reserve category for the post of headmaster, headmistress of provincialized ME, MEM, MB and senior basic school of district of Alakandi. The state may initiate the process for promotion of the petitioners and other similarly situated employees to the post of headmaster in accordance with the notification dated 22/3/2010 within a period of
2 months, my lord.
initiate and complete the process within a period of 4 months from the date of passing of this order. With these applications, the special appeal, the writ appeal is disposed of.
Highly obliged.
We can fill along with the connected writ petition. There are connected matters also.
Yes, my lord.
26, 27, 28 and 29 are connected.
Yes, my lord.
Connected writ petitions-
We can fill along with the
connected writ petitions are disposed. Yes.
Highly obliged, my lord.
in the beginning, the post of headmaster, posts of.
Item 31.
This is a repetition prepared by the Income Tax Department against the order dated 14/3/2019, whereby the payment of 4,800 was granted to the petitioner lordship. But the rule does not provide for them.
Great.
Page 20 is the order passed by the learned CAP law.
Page
Page 20. Operative part is page 25.
Yes.
The learned CAP on the basis of one order passed by the Ernakulam bench. And the fact of that case was quite different from this case.
Yes, ma'am.
Lordship.
If there is no such grade, then how can this such grade can be granted?
Lordship, we may we please grant us like 4 weeks time for filing this application.
Ordinance 2019.
Lordship, earlier we filed there was some defects was there, so you were allowed to withdraw the petition and file again.
When you are allowed to?
Lordship, petition number 1419/2022.
2022.
Yes.
2019, you have preferred a writ petition in 2022.
Lordship,
And
the respondent did receive the notice. Then we will allow to
petitioner has submitted that the tribunal has had in directing to grant the respondent rate pay of ₹4,800 from 29/1/2010. Has submitted that the direct taxes attached and subordinate officers, senior translator, Recruitment Group B, non-gazetted / non-ministerial post, bracket close, Recruitment Rules 2018 do not provide for a grade pay of ₹4,800 for the post of senior Hindi translator. Issue notice. And informed appearing for the respondent and so and so. Accept notice on behalf of the sole respondent. She placed some time to file. Service is therefore complete. She placed some time to file counter to the writ petition. Time paid for is granted.
They have not implemented the order.
You have not implemented the order till date.
No,
There is
it
no
is not
content.
implemented. We prayed for stay of the order also.
They pray for the interim order be considered. After counter is filed. Counter to the writ petition is filed.
Much.
Item 32.
May I please, Lordship? Lordship, till now, only the respondent number have filed their affidavit, Lordship.
Oh.
Lordship, if the other respondents wanted to file, Lordship, let them file, and in the meantime, we'll reply, Lordship.
You'll reply to what?
For rejoinder, we'll file the rejoinder affidavit, Lordship.
My lord, the petitioner challenged my lord, the power of the autonomous council to enact the law, my lord. And we have enacted the law, my lord. And the petitioner challenged that the virus of the act, my lord, that we have no power to enact the law. That is a matter of law point, my lord, Lordship will decide the issue.
Interim order operating here.
The interim order, my lord, regarding the eviction at that period of time. Single judge has already decided the other cases, my lord. By following the rule 18.2 of the Assam Land and Revenue Regulation 1886, we can, my lord, evict the persons. And the other repetitions, similar repetition has already been disposed of by the single judge. In this particular case, the point is required to be decided whether we have the power to enact the law. If we don't have the power, then we cannot evict the persons, my lord. So that is the law point that can be decided by fixing a date of hearing, my lord. At any date, my lord. We have filed our affidavit, my lord, that we have the power under the 6th schedule of the Constitution of India. Accordingly,
File counter to the reply.
Lordship, yes.
We can reply to
2
the
weeks may be granted, Lordship.
yes.
2 weeks may be granted for filing the rejoinder.
The petition, the counter to the writ petition is filed on behalf of the respondent.
Response number 3, my lord.
Respondent number 3. The other respondents have not filed any counter.
My lord, that it is, my lord, the autonomous council, my lord. Under the 6th schedule, we have, my lord, filed the affidavit on behalf of autonomous council.
The other respondents are not required, are not supposed to file any counter to the writ petition as the petitioners have challenged the power of the Karniang, so Anglong Autonomous Council of legislating the laws. Stop. Learned council appearing for the petitioner placed some time to file counter to the reply of the respondent number so and so. Time paid for is granted based on so and so.
Plus the interim order to be continued.
Interim order to continue till next date.
Humbly obliged, Lordship.
June में June की date है कुछ कर देते
Item 34 and 35.
My lord, in both the petitions, my lord, both the petitioners were appointed on contractual basis as computer assistants under the my lord, Panchayat and Rural Development Department, my lord, in the year 2012. So, my lord, the issue is here, my lord, that both the petitioners terminated. My lord, in item number 34, page number 62 is the termination order. That termination is without affording any opportunity, your lordship, and this is in violation of the principle of natural justice, my lord. And this issue, my lord, this honorable court in several recent judgments also held, my lord.
The termination order is stigmatic.
Yes, my stigmatic, my lord, page
How?
number 62, my lord.
Read your termination order.
My lord, in view of the anomaly noticed in the MIS, MG and Rega for the financial year 2014-15 and 15-16 regarding pending liability of material component of MG and Rega, and on basis of the statement submitted by block development officers and program officers regarding freezing of material bills and in exercise of powers as incorporated in the terms of contractual engagement under MG and Rega, Sri Ramchandrapal Computer Assistant Tapang Development is hereby terminated from the contractual agreement.
So how it is stigmatic?
Yes, my lord, their duty was there, my lord. The petitioner's duty was in the computer section, my lord, regarding the preparation of bills.
Stigmatic towards you.
Yes, my lord, regarding the anomaly, my lord.
In view of the serious anomaly noticed in the financial year so and so regarding the pending liability of the material component of Mangera on the basis of the statement submitted by so and so regarding freezing of material bills and exercise of power. So how it is stigmatic? They have simply stated a fact.
Yes, my lord, we are engaged in, my lord, this preparation of the bills, all this, my lord, computer generated, my lord, MIS bills, my lord, our duty was there, my lord, in the computer section, my lord. So, my lord, since these anomalies are mentioned, my lord, on the basis of the anomalies, we have been, my lord, terminated, my lord. That is my lord.
Can't be a stigmatic in any way.
On the basis of the anomalies, my lord, the foundation is that, my lord, that due to anomalies, we have been terminated, my lord.
Yes.
So, my lord, since the order is therefore stigmatic, my lord.
Yes.
So no other reason is assigned, my lord, in this order, my lord, as to why we have been terminated, whether it is, my lord, expiry of our period of contractual, my lord, or any other, no other ground is except this, my lord, anomalies, my lord. So since the basis of the, my lord, anomalies in the MG and recommend, we are entrusted, my lord, the duties of the, my lord, this computer preparation of bills and all this, my lord.
That's all.
Yes, my lord, that is, my lord,
Agreement permits the authorities to terminate.
my lord. So,
There is a clause in the contract to terminate it.
yes, my lord.
Then
They have
So-
terminated not in between, after expiry of your extended period. They have terminated.
My lord, the last agreement I have annexed, my lord, page number 59, my lord. It was, my lord, on 2nd of April 27.
Yes.
And we are, after 2 months, we have been terminated, my lord. During the subsistence of this agreement, my lord, page number 59, my lord.
Yes. Anything else?
No, my lord, this is the, my lord, I have, my lord, supplied some of the, my judgments, my lord, of this honorable court, my lord, regarding, my lord,
Court has taken into consideration in review petition. They have considered that.
Yes, my lord. But after the review petitions, my lord, I have submitted, my lord, some of the judgment, my lord, the recent one judgment I have submitted earlier, my lord.
Yes.
This judgment, my lord. The recent judgment, my lord, the last one, my lord, one. Ali Ahmed judgment is my lordship's judgment is there, my
You
lord.
are referring to?
Only on this, my lord, point.
Which judgment?
My lord, Ali Ahmed judgment is there, my lord. The last judgment is, my lord.
Brigan Kalita.
Mrigan Kolita also, my lord, this stigmatic order, he was my lord, arrested, my lord, Mrigan Kolita, my lord. And on this arrest, he was, my lord, terminated. And my lord, in his case, my lord, the arrest is held to be stigmatic, my lord.
Arrest is altogether different things, sir.
Yes, my lord.
Arrest you on the ground of corruption. Ground में
And in the case of Ali Ahmed, my lord, my lord,
नहीं कर सकते नहीं.
अच्छा, लोग
Issue. ये observation last for them. इसमें discontinue continue. Stated.
This writ appeal is and on behalf of the petitioner being agreed with the order dated 22/12/2021 passed in. Writ petition number appellants करते हैं ना appellants. Writ petition number 2988/2018 whereby the writ petition filed by the appellants has been dismissed. The appellants has approached this court by way of filing the above referred writ petition challenging the termination order, challenging the action of the respondents of discontinuing them from the contractual engagement. The learned single judge is of the view, was of the view that engagement of the appellants were for a temporary period and during the pendency of the writ proceedings, the period of engagement of the petitioner has already expired and no fresh engagement was issued in favor of the petitioner. The learned single judge has observed that the law is well settled that the court cannot direct the parties to enter into a fresh contract when a matter is governed by the contractual liabilities. The learned single judge has placed reliance on a decision passed by the coordinate bench in Ajay Kumar Aloi versus State of Assam, reported in Manu/GH/0309/2014. Stop. It appears that being agreed with the judgment dated 22/12/2021, the appellants have preferred a review petition before the learned single judge, which came to be dismissed on 14/2/2023. The learned single judge in the learned single judge, while dismissing the review petition, has observed that the case is relied upon by the appellants. That is writ petition WPC number 1964/2020, Sanjay Kaidi versus State of Assam and others, decided on 21/2021, and writ petition number 8618/2018, Surojit Roy versus State of Assam and others, decided on 9/12/2020, are clearly distinguishable because in those cases, the termination orders were stigmatic and were passed by the employer without providing any opportunity of hearing. Whereas in the cases of the petitioner appellants, the order of discontinuance of their contractual engagement cannot be said to be stigmatic. Full stop. And the concept of the appellant has placed reliance on the decision of this court passed by the single benches in so and so, mention the name of it, and has submitted that in similar situation, this court has granted indulgence and has set aside the termination orders while treating them as stigmatic. And it counsel has further submitted that the order of discontinuation of the services of the petitioners is stigmatic, and therefore the same is also liable to be set aside. Stop. Then it counsel appearing for the respondent as opposed, they will appeal. Stop. Having heard the learned counsel for the petitioner appellant, and after going through the order dated 14/6/2017, whereby the services of the appellants have been discontinued, we are of the view that the said order cannot be termed as stigmatic because the contractual engagement of the appellants has been discontinued on account of serious anomalies noticed in financial year 2015, 2014-15, 2015-16 regarding pending liability of material component of Manrega. Stop. The said anomaly cannot be termed as full stop. It's clear that the order of discontinuation of contractual engagement of the appellants is not stigmatic. Hence, the judgments on which the counsel for the appellant has placed lands are of no help to the appellants. Having gone through the material, we are of the view that no case for interference is made out, and the special appeal is therefore dismissed. Two appeals. Special appeals are therefore dismissed.
Item 36.
Lord, in this case, before I make my submissions on merit,
I think Honorable Justice Shyam had already read the judgment in another matter, my lord, which is subject matter of writ appeal in 344 of 23. That's, my lord, that Ayurvedic doctor's case. Yeah, yeah.
There is a Supreme Court judgment also.
Yes.
In it is
P.M. Bhatt. Yeah. So, my lord, there are another one judgment of Supreme Court, Jammu and Kashmir High Court, Uttarakhand, and my lord Gujarat.
But the Supreme Court has ruled that they can't be paid the equivalent to these.
Exactly, Ram Naresh.
Yes.
My lord, in Ram Naresh, Supreme Court said how the treatment is imparted, that is not important. End of the day, be it allopathic doctor, be it homeopathic doctor, be it Ayurvedic doctor, they treat their patient. So there you cannot bring in any intelligible classification. my lord.
No, there is a judgment authored by Honorable
Bhatt.
Justice Ram Subramaniam.
Who is retired, yes.
Yes,
The Lordship has relied upon that judgment.
yes.
And
That is the
this
latest.
segment.
Correct.
And what happened in that this Medical Officers Association of State of Gujarat?
Yes, there, my lord,
Wherein they sought.
Gujarat Supreme Court has upheld it, my lord.
No, they sought now.
In fact, my lord, we have made the compilation of the judgments.
When review application is preferred against.
No, review is rejected, my lord.
That has.
Review is rejected.
That what remain?
No, my lord, what had happened, there are three other High Court judgment and, my lord, which is upheld by the Supreme Court.
But if on a very.
Only one judgment was taken note of.
If the writ petition itself whereby under Article 32.
No, here Lordship will kindly see what was challenged before the learned single judge was not entitlement. The learned single judge, Justice Michael Jotankoma, had said no, they are entitled. While implementing the order, my lord, some infirmities has crept in. We have challenged that. On principle, my lord, the judgment is in our favor.
Then you should have filed.
Then, my lord.
Then you should file a review petition.
No, what had happened, if the Lordship would kindly come to the judgment, my lord, of Michael Jotankoma, which is at page 158. In any case, I thought, my lord, since Honorable Justice Shyam was the.
Judgment is of the Justice Barua.
No, what happened? And prior to that, my lord, there is a judgment of Justice Jotankoma at page 158.
Before another bench, one of us. Justice Sunil Chap is not on that.
Deep left.
Item 38.
One judge. 7 years.
Lordship, the petitioner praised that the mandate of the passport issuing authorities and the registrar of death and birth to record the original place of birth with regard to the adopted child in inter-country adoptions, Lordship, not inter-country, within the country. There's two kinds of adoption, Lordship. One adoption happens inter-country, that adoption, the child goes to other countries. With regard to these PI, Lordship, we are only concerned with the adoption that happens within India, Lordship.
Within the country.
Within the country, Lordship. So our prayer is, while issuing a passport, Lordship, there is a mandate which says that the place of birth, the original place of birth be recorded in the passport. While in with regard to adoption, all other information can be masked.
with regard to the date of birth, name of the parents, everything is as per the adopted parents, the parents who adopts will decide, Lordship. Only with regard to place of birth is the mandate which,
How you are affected by that?
Lordship, because what apprehension has been shown by the petitioner, Lordship, what is that if a person from Assam adopts a child from any other state and the name of that state is recorded, there may be a situation when the child will come to know eventually that he was adopted, and the adoption is based on confidentiality and privacy of the child, and also the interest of the child is paramount, Lordship. And
Is the petitioner proposing to adopt any child or?
I have no instruction to that regard, Lordship, but what he says, he has, as he's been recording petition also, he has seen some passports where it has been recorded, and he came to know what has happened after that with some socially other persons, Lordship, who he knows. And Lordship, apprehension is also that if the original place of birth is not recorded, it will not hamper because the records are already maintained by CARA with regard to the place of birth.
Lordship, so far as his submissions are concerned, Lordship, I'll just give an example, Lordship. My parents are, it's for me, my parents are from Barpeta. I was actually born in Dibrugarh, Lordship. No, that does not make any difference.
That's
Lordship.
another thing. That's altogether another.
No, here.
Suppose a person adopts a child who is born in Telangana and now he lives in Assam. After being adult, suppose he came to know that how you were being to Telangana, how I was born in Telangana.
Lordship,
that is exactly the apprehension.
That's the only, not on Assam, Barapeta and all this.
And also not,
so far as adoption is concerned, Lordship, as per the rules, Lordship, if it is institutional, Lordship, it is the place where he was, the institution place where he was adopted, that would be considered as his place of birth.
In this,
as per the rules. And if it is not institutional, then from the place from where it is adopted, that would be considered as the place of birth. If I may take your Lordship to my annexure 1. Annexure 1 in the affidavit. Page. Running page, it will be 104. It's a circular dated 12/3/2012.
admission. You hear it. Admit, no need to issue notices, parties are already represented. This matter of in August. For hearing in 2020, August 2024.
Obliged. Item 59.
May it please your lordship. Lordship, in this case, I am challenging the appointment of a special public prosecutor of the POCSO Court, Barpeta district. Lordship, what has happened in this matter is that Lordship.
Lordship, may I say something? Lordship? Today we have filed an affidavit, Lordship. It has not been on.
You are for?
I am for respondent number 7.
The private respondent.
Private respondent number 7, Lordship.
If there is no, this POCSO Act, there is no provision for consultation.
Lordship, there is, Lordship. If I may so, Lordship.
There is.
Yes, Lordship. Lordship, section 32 of the POCSO Act, Lordship.
Yes.
It says that the state government shall by notification in official gazette appoint a special public prosecutor for every special court for conducting cases only under the provisions of this act. After the Lordship, a person shall be appointed for example not less than that 7-year this is given Lordship. Third is every person appointed as a special public prosecutor under this section shall be deemed to be a public prosecutor within the meaning of clause U of the section 2 of the Code of Criminal Procedure 1970 Lordship. And the provisions of them shall have the effect accordingly. Now, Lordship, if Lordship says, Lordship takes up Prevention of Money Laundering Act, Lordship.
How is deprived is it? How you have been deprived because of this?
Lordship.
Your claim is that you have been deprived.
No, Lordship, my case is that Lordship, there are two posts are vacant, Lordship. May I proceed?
You have received copy of the counter.
I have received a copy, Lordship. In this affidavit, I have gone through it, Lordship. Apart from personal allegations against me, there's nothing much.
You don't want to rejoin.
I don't want to rejoin, Lordship. There's nothing to rejoin, Lordship.
The respondent number 7 is the person who was appointed.
Yes, Lordship. Respondent number 7 has been appointed.
Find their counter, what they want to say, because they are the directly affected party. You look here, Mr. So-and-so for respondent number 7. Raise some time to.
He has already filed today. You already filed.
He has filed it.
Registry, High Court's approval is required for special PP.
No, my lord. Section 32 is very clear, my lord. My learned friend is relying on the subsection 3, which says every person appointed as a special public prosecutor under this section shall be deemed to be after he is appointed.
Yes, why you have made the registrar general as party here?
My lord, I'm sorry, my lord, that might be a mistake on my part, my lord, because as the respondent security of the district I had made him party, maybe struck of Lordship.
There's no need of that. Anybody is appearing on behalf of the registrar. You are appearing for the registrar. Huh?
His name may be struck of my mistake on my part.
Instructions, material instructions are complete. So we'll delete your name from here.
So far as my friend Mr. Mahanta is concerned and me, my lord, our instructions would be completed in a different way. So far as private respondent is concerned, the doctor may ask the question.
So nowadays dematerialized instruction is also coming.
You are appearing for the respondent number 4 also. And from respondent number 6 also.
6 also. Madam, yes, in this case, madam, regarding appointment of the
there is no requirement of this. Okay, whatever. Parties are represented through their counsel. Respondents are represented through their counsels. Counsel appearing for the respondent number 7, trace some time to file counter to the petition, time paid for his grant.
Respondent 7 has already filed.
Asha, you have already filed.
Same is not on record.
We also filed.
File counter to the petition. However, the same is not available on record. List after
next
3 weeks.
It's already late, Lordship. It was filed last year in July, Lordship.
So you are only dependent on this, the petitioner is only dependent on this public prosecutor post, or he is also practicing
law?
No, most of the time he has been in a public prosecutor, Lordship, for the most of the part of his career.
So give some others also chance.
Yes.
Her husband, my lord, who was 38 years of age. My lord, she was kidnapped in April 2020. Then thereafter, my lord, the SIT was constituted as per order of this court. And accordingly, my lord, SIT has submitted its charge sheet.
Counter.
Yes. My lord, yes. Counter, they said there is no provision for payment of any amount for custodial debt. My lord, your lordship may kindly see page 95 of the charge sheet starts at page 55. Relevant, my lord, paragraph at page 95, your lordship may kindly see.
Yes.
Page 95, my lord, the particular paragraphs. During investigation of the case, it has been revealed that the police officers, namely Gogoi, APS, and then Superintendent of Police, Dima Hasao, Sri Suryakanta Moran, then my lord Sri Surajit Kathar, Sub-Inspector, then my lord Shankar Bania, then Tuolor and CN Projit Rajvamshi were involved in the case for criminally conspiring to kidnap, torture and murder Santosh Hojai, and after the death of the victim, criminally conspiring against to bury the dead body of victim Santosh Hojai and manipulating the pages of general diary entry, register and arms and ammunition register in an attempt to conceal and destroy the evidence as sufficient evidence in the form of oral, documentary, digital and circumstantial has been found against them. The above mentioned accused persons belong to Assam Police. Being police officials, they willfully breached and neglected to follow the legal provision, procedures, rules, regulations applicable to the members of the Assam Police Service. The said police officials picked up victim Santosh Hojai, detained him illegally and without having any lawful authority. Further, the said police officials tortured the victim Santosh Hojai during their custody and did not provide any medical assistance, as a result of which the victim succumbed to his injuries. And the said police officials buried the dead body of the victim in an attempt to conceal the evidence of the heinous crime.
Mr. Das, is it admitted that they were police personnel?
Yes, it is admitted.
It is admitted.
It is admitted. So therefore, my lord, at the relevant point of time, this man, he is a businessman. He was earning about 5 lakhs rupees. He had a loan of about 97 lakhs rupees. That I have annexed the document. So in view of the, my lord, decision of the Apex Court, my lord, 2022 7 SCC, my lord. My lord, motor vehicle, my lord, the provisions of the Motor Vehicle Act will apply for the purpose of determinations of the compensation. This is a fire tragedy, but ultimately it has been discussed. Neelavati, Vera, and all other cases have been discussed. Your lordship will kindly see paragraph 1467. This is the latest I found, my lord. All cases have been discussed. Paragraph 14, 64 and 67, your lordship can listen. State affidavit नीचे है। State का affidavit नीचे है। ये superintendent of police.
Is there any affidavit by the state?
Yeah, affidavit has been made. They say there is no provision for payment of any.
Affidavit has been filed by state?
Statement.
We have only one scheme. Victim compensation scheme.
Mr. Bora, affidavit has been filed by which respondent?
Respondent number 5.
But that is not state.
It is not state, but he was authorized by the state.
Superintendent of Police.
My lord.
Ultimately, if we comes to the conclusion, the liability of the state.
My lord.
State response is necessary for that.
My lord, all right. We'll file affidavit, my lord, on behalf of state.
You are appearing on behalf of?
I'm my lord, state respondent.
All the state respondents
My lord.
filed affidavit of the Home Secretary here.
No, yes, my lord.
Yeah, either chief secretary or home secretary.
Except three, man. Three is a council.
Number one or two. Let me see.
Because ultimately, once it is in the inquiry, it is established that the charge sheet has been.
Yes, charge sheet has been filed, my
Hearing
lord.
officer, then certainly the liability of the state is there.
Yes, my lord, all are police officials.
Whatever the vicarious liability of the state.
Yes, my lord.
Madras High Court is-
My only question is for a death, my custodial death.
No, I find one Madras High Court judgment also where custodial death, they have followed MSCT provision. Salda Devi. That also, it's custodial death, Madras High Court followed the provisions of the MSCT for the purpose of.
What is the computation according to you?
Malad,
What should be the
competition,
amount?
Malad, if we take into because Malad, this is under the. I'll give it, Malad. Because Malad, your lordship knows, Malad, in NCLs, Malad, there is no income tax filing. They do not file any income tax. So therefore, Malad, he's from the bank statements and the amount of money he was providing towards loan, Malad. It comes, Malad, we have stated that his income is about 5 lakhs rupees per month. Competition to follow. Calculation Korean. मतलब एक तो गवर्नमेंट को बता बट कॉपी तो करनी है calculation to
This petition is filed by the petitioner.
calculation comes 4.5 crores. Malad, if we take into consideration, yes, I'll give, I'll have to type it into.
To the state respondent.
Malad, I provided two judgments. Madras High Court judgment and the Supreme Court judgment.
To make a payment of compensation to the tune of rupees 50 lakhs to her. Because her husband was died in the police custody in connection with the case number 3/2020. Registered at PS Harangajo. Stop. It is contended that in the inquiry conducted by the state, the victim of custodial death of the husband of the petitioner has been fully proved, and the erring police officials were also charge sheeted. Stop. The counter to the writ petition is filed on behalf of the respondent number 5 only, who is the superintendent of police. Of Haflong, Bima Hasao, Assam. However, no counter on behalf of the state or the Home Department. It's fine. It's fine. We grant 2 weeks time to the state to file counter to the writ petition supported by the affidavit either of the Chief Secretary of the Government of Assam or the Principal Secretary, Home Department, Government of Assam. List this matter on date May की yes, up to 2 weeks.
Deeply obliged.
I am deeply obliged.
Yeah. Yeah.
Supplementary list, item 48 and 51.
I'll get that there.
May it please your lordship. This is a petition, review petition filed by the state of Assam against the order dated 1/6/2023 passed by the division bench in writ appeal number 42/2023.
42/2023.
42, page 101 is the order against which we are seeking review, lordship. 101 India page number.
101.
Yes, lordship. Here also, lordship, there are several paper books. So let me place from the review application. It is review 6/2024. Page 26. Contempt of It starts at page 27. But before going to the appellate order, lordship, I would like to place the learned single judge's order, which lordship will find at page 18.
Yes.
Order dated 24/11/2022. Second paragraph, pursuant to an advertisement of 2016, the writ petitioner was appointed. The case in a nutshell is very simple, lordship. In 2019, the writ petitioner was appointed as.
Let us go through the order of the learned single judge.
Yes, that is why I'm placing. May I place it then?
Yes.
Pursuant to an advertisement issued in the year 2016, to which the petitioner applied and participated in the selection process, the petitioner was appointed on probation as an OBC candidate to the Assam Land and Revenue Service Junior Grade by a notification dated 9/1/2019 issued by the Department of Personnel. Thereafter, the petitioner was posted as circle officer to Margherita district by notification dated 24/1/2019. The Anti-Corruption Liberation Union, respondent number 7, filed an FIR before the officer in charge, Jorhat Sodar, on 24/7/2019, alleging that the petitioner's father is from the general category and therefore the petitioner cannot possess an OBC certificate. Accordingly, the petitioner was directed to appear before the state level scrutiny committee on 17/11/2020 by a communication dated 12/11/2020. The said state level scrutiny committee was rescheduled on 18/11/2020. The petitioner thereafter appeared before the state level scrutiny committee on 18/11/2020 and explained the reasons with regard to obtaining of the OBC certificate. Thereafter, the state level scrutiny committee by a speaking order on 26/2/2021 recommended that the OBC certificate issued to the petitioner should be cancelled by the appropriate authority with immediate effect. Being aggrieved, the petitioner before this court by way of the present writ petition, impugning the speaking order dated 26/2/2021. Then there is narration of the Madhuri Patil's case. Next, page 21. At this stage, D. Mujumdar Lanet, Additional Advocate General Assam, has produced the record before this court, which contains the enquiry report submitted by the SP CID Assam with regard to OBC certificate of the petitioner. The enquiry report is dated 3/10/2019 made by the Inspector of Police CID Assam. The enquiry report is also reproduced herein below. The first part I am skipping, that is relating to 3 persons. The relevant portion at page 22, serial number 1. In respect of Srimati Monsoon Borkakoti, I visited her parental address and present address, that is Golaghat and Jorhat. In course of enquiry, it is found that father of the alleged, namely Sri Dr. Santanu Borkakoti, born and brought up at Silpukhuri, Guwahati, followed the original rights, that is rights of Kolita community, and got appointed as medical officer who was posted at Jorhat. The said doctor got married to a lady at Jorhat hailing from Koch OBC community and used to reside at matrimonial house wherein the alleged Miss Monsoon Borkakoti got birth at her mother's house on 12/4/1990. And since then, she started her education at Jorhat and accepted the custom of Koch community. This lordship will kindly mark. Accepted the custom of Koch community. During 2006, while she was the student of class 10, she applied for OBC certificate on the merit of her mother's custom. In fact, the father of the alleged, though got appointed as MBBS doctor, however, he was not moved for OBC certificate as he was not born at Koch community. It is pertinent to mention here that in respect of issuing OBC certificate, Honorable Supreme Court passed a verdict referred to civil number so-and-so on 18 January, and in connection with appeal, Honorable Supreme Court of India passed judgments that the child generally belongs to father's caste. However, the child can claim mother's caste also in certain situations, that if the child is born and brought up at the house of the mother who is hailing from other community than that of her father. In fact, the judgment promulgated not directly related to OBC community. However, the situation incorporated carried the ingredients for which the alleged Monsoon Borkakoti is seemed to be entitled for obtaining OBC caste certificate. Moreover, the issuing agency clarified that the certificate issued is genuine and issued from their office. The photocopy of the OBC certificate issued by the President, All Assam Other Backward Classes Association, Guwahati. Copy of the certificate issued by local Gaonbura, namely Digonta Borua of Sekonidhora Gaon, number 3, Town Moja, East Jorhat Revenue Circle. Local Gaonbura certificate issued by Sri Torun Chandra Hazarika Gaonbura of Betioni, Kakuti Gaon, Moja, Dhekial, Golaghat, and copy of judgment passed by the Honorable Supreme Court of India in connection with civil appeal number so-and-so decided on 18/8/2012 were enclosed here as Annexure A. As such, it is established that the allegation brought against Srimati Monsoon Borkakoti, daughter of Santanu Borkakoti, resident of Club Road, Jorhat, is based on no truth. The complainant perused only the father's caste, but did not go through the legal findings of the Honorable Supreme Court. So this is the opinion of the vigilance officer. Now, page 25. Perusal of the enquiry report dated 3/10/2019 clearly indicates that the allegation brought against the petitioner is based on no truth, and accordingly the closure of the enquiry was recommended. Perusal of the records produced by the learned additional advocate general also indicates that the respondents has proceeded in terms of the procedure laid down by the Honorable Supreme Court in case of Kumari Madhuri Patil, and the final report was submitted on 3/10/2019. Accordingly, considering the enquiry report dated 3/10/2019, the impugned speaking order dated 26/2/2022 issued by the state level scrutiny committee against the petition is set aside and quashed. The petition is disposed of accordingly. So here, one important thing which Lordship may be pleased to note down, that I have already indicated that she has accepted the custom of Koch community of her mother. Whether that is permissible in broader context of caste determination. Now, against this, the third party who lodged the complaint, they have filed a writ appeal at page 42, 2023, page 26. Here also, the Honorable looked into every nitty-gritties, and paragraph 4, one important line I would like to place, page 30. This is of course the submission of the other side. However, last line, based on the fact that the girl child was residing with her mother and was following the customs and rituals of the coach community, a certificate dated 13/11/2006
You are
was,
reading from para 4.
yes, from paragraph 4, last line.
Yes. However, based on the fact.
Fact that a girl child was residing with her mother. Lordship will also keep a note of this, that she was residing with her mother and was following the customs and rituals of the coach community, and a certificate dated 13/11/2006 was issued in favor of the respondent writ petitioner affirming that she belongs to coach community. Then there was an issue of non-creamy layer also, because the father is a doctor, mother is also a gazetted officer. So that issue was not an issue because that was although indicated here, but it was not the main contention. So I'm skipping those parts. Now what? Now the finding of this honorable court at paragraph 14, page 37. In the wake of discussions made herein above and keeping in view with the categorical affidavit filed by the state government authorities before the learned single judge, placing on record the report dated 3/10/2019, which was prepared after thorough inquiry conducted by the vigilance officer. Lordship will also keep a mark of this thorough inquiry also, that part. Conducted by the vigilance officer, that is Inspector of Police CID Assam in the present case, under the supervision of the Superintendent of Police CID Assam, concluding that the allegations regarding falsity of the social status certificate of Srimati Monsoon Borkakoti was based on no truth. The only course of action required to be taken as per the ratio of the judgment of Kumari Madhuri Patil was to accept the said report of the vigilance officer, that is Inspector of Police CID. For the sake of repetition, it may be mentioned herein that the state level scrutiny committee, after passing the impugned speaking order dated 26/2/2021, did not objectively consider the inquiry report of the vigilance officer, that is Inspector of Police CID, which was mandatory requirement as per the guidelines laid down by the Honorable Supreme Court in Kumari Madhuri Patil. A perusal of the said speaking order would reveal that the scrutiny committee though referred to the report submitted by the Superintendent of Police CID Assam, but thereafter no discussion whatsoever was made to the findings of the inspector's report in the speaking order. On the contrary, while coming to the conclusion that the respondent writ petitioner were not entitled to the benefit of OBC certificate, the scrutiny committee relied upon a parallel report which was conducted through the Circle Officer Jorhat Revenue Circle. Apparently, in terms of the judgment of Kumari Patil, the Circle Officer has no jurisdiction to carry out such inquiry. Furthermore, the finding recorded in the speaking order that the mother of Srimati Monsoon Borkakoti obtained caste certificate as belonging to Coast community in the year 2019 is also also an extraneous and irrelevant observation, because, as has been referred to in the service record, Srimati Purnima, the mother of the respondent petitioner, her caste is mentioned as Coach OBC. 15. Testing the report of the vigilance officer, that is the inspector of CID, on the touchstone of the principles laid down in the case of Kumari Madhuri Patil, we find that the inquiry report submitted by the inspector CID does not indicate, even in slightest, that the particulars given by the candidates were false or that the social status certificate had been fraudulently obtained. Thus, in terms of the first part of paragraph 13.7 of the guidelines formulated in Kumari Madhuri Patil, which provides that in case the report is in favor of the candidate and found to be genuine and true, no further actions need to be taken. No further action was called for in the present case after the detailed and reasoned inquiry report had been submitted by the inquiry officer. However, the SLSC got another parallel inquiry conducted by through Circle Officer Jorhat Revenue Circle, who apparently had no jurisdiction to carry out such inquiry as indicated above. Another significant fact which needs to be noticed is that the report of CID is Inspector CID, which was submitted after conducting a thorough inquiry in terms of Kumari Madhuri Patil, did not give any indication that the social status certificate was obtained by the respondent writ petitioner by providing any false or fraudulent information, rather concluded that the social status certificate was validly and lawfully obtained. The authorities has no option but to accept the report and affirm the social status certificate of the respondent writ petitioner as per the guidelines contained in paragraph 13.7 of the judgment of Kumari Madhuri Patil. Hence, contrary conclusion drawn by the state level scrutiny committee is absolutely illegal and unwarranted. As a consequence of above discussion, we are of the firm opinion that the learned single judge was perfectly justified in accepting the writ petition filed by the respondent number 1, herein and quashing the speaking order dated 26/2/2021 passed by the state level scrutiny committee and affirming the social status of respondent number 1 herein as OBC. Thus, the impugn order does not suffer any infirmity, and as a consequence, writ petition fails and same is dismissed as being devoid of merit. For the contemplation on the additional affidavit of
Yes.
Yes. So far, so good. The state government was about to comply with this observation direction. If Lordship is pleased to take the, I would like to give the sequence of events thereafter in the contempt case. In one paragraph, we have narrated date-wise in chronological order. Item, the other item, which is that
Yes.
page 62. Thereafter, the writ petitioner filed another writ petition seeking her reinstatement because she was under suspension when this complaint came. In that case, we did not comply it. The process was going on. And during that time, an order was passed on 13/12/2023 in the contempt case. In the sequence of that, Lordship, we are narrating the whole sequence of events. Paragraph 4. On 24/11/2022, Honorable High Court in WPC so-and-so has disposed of the writ petition by setting aside the impugn order dated 26/2/2021. That is the findings of the scrutiny committee. Sorry, single judge's order. No. 24/11, that is a single judge's order. Then page 30.
What is 26/2/2021?
SLC, the scrutiny committee's decision to set aside her was their OBC certificate, which was impugned in the writ petition.
Yes.
Then on 30th, she submitted a representation for revocation of her suspension order. Then 19/12, the personnel department sought a report from the tribal affairs department whether any appeal has been filed against the honorable court's order dated 24/11/2022. Then 14/2, the personnel department has sought views of the judicial department. 17/2, the honorable high court has directed the secretary personnel department to reinstate the petitioner, that is in the writ petition, forthwith, considering her representation, because the very edifice has been of suspension was already set aside by the honorable court. Then 1/3, the legal remembrance or judicial department has opined that the government respondent in WPC so-and-so and WPC so-and-so has not challenged the order in the writ petition as there is no reflect of the same in the record. In the event of order dated order of WPC 2286 attaining finality on being not challenged, the order dated 682 appears justified the department to comply the order of reinstatement of monsoon. Then 19.3, the secretary, personnel department moved the file for reinstatement of monsoon Borkakoti before the competent authority, the Honorable Chief Minister, for approval of the same, which may kindly be referred as note sheet number so and so. So on 9/3/2023, the concerned personnel department wanted to reinstate her and send the file to the Chief Minister. On 23/3/2023, the Honorable Chief Minister has instructed to review the matter since finding of the CID and the state level scrutiny committee DC Jorhat are contradictory. And LR has inter alia highlighted that the state respondent has not challenged the order of Honorable Guwahati High Court. Thereafter, so-and-so may be approached by the personnel department, social justice and environment department to offer his advice on filing an appeal petition against the order of Honorable High Court, may be referred at note sheet so-and-so. 7.4, as per instruction of the Honorable Chief Minister, the Principal Secretary Personnel has directed to take detailed opinion of AG. Then 19.5, the AG opined that the judgment dated 22/2/86 of and all subsequent orders required to be challenged before a larger bench by filing a writ appeal while explaining the issue of limitation of by reasons. So on May 19, the government decided that appeal has to be filed by giving justification regarding the delay. 14/6/2023, the Honorable Chief Minister has instructed Personnel Department to immediately file writ appeal as advised by AG and to request AG to represent a state in the Honorable Guwahati High Court, which may kindly be referred to as note sheet so-and-so. So 14 June 2023, the government come to a decision that immediately we should file the appeal. The interesting part was that the third party had already filed an appeal, and on 1/6/2023, the appeal was already dismissed, which I am seeking review now, coming further now. 16/6, accordingly, as instructed by Chief Minister, the records of file number so-and-so was sent to the office of the AG for filing the writ appeal. Thereafter, there is a gap. 3/12/2023. In the meantime, the state came to know about the dismissal of the writ appeal between 16/6 and 3/12/2023. Here, there is a development also. 3/12/2023, the AG opined that the state government may either start a fresh inquiry regarding the verification of the caste certificate or to prefer a review petition before the Honorable Division Bench for review of the judgment of so-and-so, placing the actual status of investigation report dated 3/10/2019 and also to file an application for extension of time pertaining to the order dated so-and-so. Then these are all subsequent developments, 4/12, 8/12, and 12/12. And 17/12. 17/12, noting maybe I would like to place lordship. 8/12, before that, the Chief Minister instructed Personnel Department by note sheet to ask for Home Department to initiate fresh inquiry by CID. 12/12, the Honorable High Court by the order dated so-and-so was received. In view of the order of the Honorable High Court, the file was again moved for reinstatement of petitioner Monsoon Borkakoti. So again, an attempt was there to reinstate her. Then the Chief Minister wrote on 17/12/2023, the competent authority, the Honorable Chief Minister has noted that the authenticity of the OBC status of the petitioner Monsoon Borkakoti is in serious doubt. While respecting the majesty of the Honorable High Court and his commitment to comply with the direction of the Honorable Court, the competent authority has expressed that history will not forgive if the petitioner is reinstated in service without final verification of her OBC status. In the backdrop, the competent authority has suggested to make a prayer before the Honorable High Court to grant the state government 15 days more time to take a decision either to implement the order of the Honorable High Court or to file a review petition in the Honorable High Court or Honorable Supreme Court with the bona fide intention of upholding fair play and justice to all concerned. This is one aspect. In the meantime, what happened in the month of June till November, that is a part of the review application now. Why that exercise was required to be undertaken for another inquiry? Yes, additional affidavit. And it's and it's yes. And the back. Paragraph 4. If Lordship is pleased to take paragraph 4 of the review application.
Review application.
Review application. I'm just placing the facts, Lordship. I'm not arguing anything because in review application, I cannot argue much to force my point. I know that. I'm just placing the, so if the facts are placed, then I'll make only 2 lines sub argument.
Just on a lighter note, you are arguing this review petition 4th time here.
4th time.
Yeah.
In fact, I have argued fully before the other division bench, which took the review at the first place. Full length hearing, 3 days it was heard, and finally an order was passed to delay, condone the delay. In fact, the condonation delay was not the issue. So I argued maybe 4 times here and 3 times then in the other court. And only for the sake of the deserving persons should not be deprived. Deserving, reserved category persons should not be deprived. That is the only intention of the state of Assam. We have nothing because she was working. She was our employee. We had no issues against individual. The issue is like whether she is genuine or whether another genuine person is deprived by allowing her to work. The other issue is, Lordship, now the non-creamy layer will always come now. Now in the inquiry, it has come out that her father is a doctor. Her mother is also in a very good position of the state government. So they cannot come under the purview of non-creamy layer. The Supreme Court is very strict on this. We have to find out who are the officials who did not verify all this.
Mr. Saikia,
Lordship.
we have in essence understood.
The main part, Lordship,
Yes,
has not,
yes,
I have not
but
placed. The main part,
there are-
why that second inquiry was direct.
No, we will come to it.
Lordship.
Just trying to understand the perspective. But what is very important is we must understand your.
Absolutely.
Therefore, these queries. Actually, there are 2 aspects. As far as the candidate is concerned,
Lordship.
the whole thing started with a complaint that her OBC certificate is not genuine because she could not have been given a certificate as OBC. That is how it started. Now, this culminated finally into the division bench judgment, which is under review. Now, the single judge, not so elaborately, but the division bench has dealt with certain issues very elaborately.
Very elaborately.
And has given a finding that there is no scope for any further inquiry. This is the end of the road as per Madhuri Patel 13.7.
Judgment.
13 point. I'm just putting the
Yes,
relevant facts. so
I'm
that
also
you can
getting my response for that.
Yes. We are formulating, trying to formulate what is the issue. 13.7 says if the CID inspector gives a finding, a report, which is free from any bias or any defect, then that's the end of the road.
Absolutely.
That's what Madhuri Patel says.
There is no quarrel on that proposition.
Right. Now, the division bench affirms the judgment of the single judge, which in essence means that no further inquiry, that's the end of the matter. After that, the functionaries, the topmost functionary of the state and the
concerned department,
the learned advocate general,
No,
gave
my
an
role was
opinion.
very limited.
That's all right. That's you are entitled to. There's no difficulty with that. Everybody is entitled to do everybody's job. But the question is, would it not amount to saying that no, we don't accept the High Court's verdict, therefore we want another inquiry? Please elucidate on. Kindly listen to the query. Please address the court on this. I'm putting it to you because we want to know what is the stand. Once the court says, the division bench says that this is the end of the road, this certificate, for whatever reason, good, bad, whatever reason, this certificate is genuine and the state has not preferred an appeal against the single judge's order. is it now open for the state to say that no, there should be another inquiry to find out the veracity of the certificate? This is point number one.
Yes.
I'm pointing this because probably these are going to be
Yes,
very
these are very
crucial,
pertinent.
very crucial points in
yes.
this matter. The second aspect is, as you are submitting, if we have understood correctly, you are saying that even if she is an OBC, even then there is no non-criminal certificate. Is not,
That issue is not never before any authorities. I'm just.
so that you are not
I
are
am
you
not
arguing
arguing.
that you are not
That is
arguing?
not, I am
Then,
not arguing.
then we'll not.
I am not. Now, suppose she goes back and joins. This issue will definitely come up now. Now it has come to the light.
Just a
The inquiry report. The inquiry report of November 3.
So, Mr. Saikia, I have also been pointed out by my Lord, the Chief Justice. And in fact, I was about to come to this. The purpose of putting these questions is to give you an opportunity to address the court on this point instead of going here. And
yes, yes.
Now, the third aspect is, you see, the division bench is given a finding with logic and reasoning. It is not the remit of this court to go into the correctness of findings or to decide whether the OBC certificate is genuine or not. The remit of the court in a review petition, you know very well.
I will.
It has to be an error apparent, something
Absolutely.
which comes within the
Absolutely.
domain. If the state, for some reason, or anybody is aggrieved by the judgment, the appellate remedy is the remedy.
Absolutely, Lordship. Now, I know my limitations. The situation as it was there on 1/6/2023, whatever was the situation.
So, corollary to that, two more
I am
points.
ready to take all
Yes.
questions, Lordship.
Yes.
I am ready.
And you are capable of. That's most important. The state has not
One
filed.
bouncer after another
The
bouncer.
state has not filed an appeal. So you are not seeking any relief from the court, either in the single bench or in the division bench. So
yes,
review why.
That is why this is a review application, and I will address whatever query is there from the honorable court. I'm not ducking the bouncers. I'm
And
going
the
to the
final aspect is, assuming whatever you are saying is correct, assuming.
Till now, everything is correct. What happened there?
Please listen. Please listen. Assuming your stance is accepted, that this certificate is bogus, sham certificate. Even then, you have to issue a notice to her and initiate proceeding, and then only you can terminate her.
I fully agree.
But you don't want to allow her to even join back on the ground
Yes.
that history will not forget.
Yes, Lordship. All these things I will justify. I will try to justify whether it will be accepted or not accepted. That is a different thing.
That's another.
Yes. Now, I do not find any fault in the division bench judgment. I do not find any fault in the judgment of the learned single judge. What has happened after 6th of June 2023? That was startling. Whether with the subsequent development, we can file an SLP or we can file a review, because those facts was never placed before this honorable court. Those were not found at that point of time. These are all subsequent development, and there are judgments I will place before this honorable court.
You are relying on Z teleflips.
No, I'll not G telefilms. The other PCCI versus Netaji,
This is
also considered by our Dhanani Sood, and lot of subsequent judgments. And for phrase inquiry also, there is judgment of the Supreme Court. So the judgment as it was delivered on 1/6/2023, it was absolutely no flaw in that judgment. I'm not saying, but had these facts being placed at that point of time, the judgment could have been the other way.
So now you have to satisfy us that the. while
Subsequent development can.
Considering the review application or the court can exercise the review jurisdiction while taking into consideration the subsequent facts.
Absolutely, Lordship.
That law you.
That law I'll place.
Yes.
But the facts also, because those vital facts are
Yes,
important.
yeah, facts.
Yes.
You explain.
Paragraph 4. May I place paragraph 4, page 7?
This is a Netaji. This is that Netaji BCCI Justice SB Sinha's judgment.
I have that. In fact, I have damaged my book. I have placing this judgment on so many cases. Yes. Paragraph 18 onwards, judgment of my Lord Justice Santosh Hegde and SB Sinha.
So is the
And the recent judgment I'll place, Lordship, on this.
Okay.
Very recent, which is not yet reported also.
No, maybe you are citing this judgment because it is BCCI or.
If you read Lordship the judgment, there are a lot of negative things about BCCI. I only take the principles regarding review from this judgment. So paragraph 4, Lordship. The petitioners respectfully state that pursuant to the Honorable High Court's order dated 24/11/2022, passed in so and subsequent order of 17/2/2023, the matter relating to service of the petitioner is under consideration of the highest authority of the government. The authority have explored the available legal remedies against the order dated 24/11 as suggested, and the department sought legal opinions from the so and so. In reply to the same highest office so and so, I'm skipping all these things, coming to the middle portion. However, in view of WA 42/2023 filed by one Anti-Corruption Liberation Union against judgment of 24/11/2022 and dismissal of the aforesaid appeal by judgment dated 1/6/2023, the department could not file the appeal, and the department was further advised to prefer SLP before the Supreme Court of India in that event. So our first stand was that when we came to know on 14th or 18th of June, we wanted to go to Supreme Court. The competent authority on 14/6/2023 has also directed the Principal Secretary, Home and Political and Personnel Department to examine as to whether there was any malafide intent or conduct on the part of the concerned SPCID and the Inspector of CID in reference to the Caste verification report submitted by them. Why this was done? Why this has played in the mind of the state government? Because two agencies of the state government give two completely opposite opinion. The SLSC, along with the help of the Deputy Commissioner Circle Officers report, gave a report which is against the petitioner, and the opinion of the Vigilance Officer, which is the Inspector of CID, is giving a contradictory opinion.
So why you are raising concern about the report of this vigilance officer and not the report of the.
That is what we are trying to find. That is what we are trying to find, Lordship. The committee consists of 5 members. Committee consists of 5 members.
Committee.
Lordship, state level committee consists of 5 members.
Yes.
Accordingly, the Personnel Department requested the Home and Political Department to make an inquiry in the matter, in which the caste certificate report was submitted by the CID officials. In response to the same, the Joint Secretary to the Government of Assam, Home and Political Department, by a letter dated 14/11/2020, furnished the letter dated 7/8/2023, issued by the IGP CID, stating inter alia that there was no malafide intent or conduct on the part of SP CID Assam in connection with the inquiry. However, the inquiry reveals that the Inspector Dibbojyoti Datta, the then inspector, has made a perfunctory inquiry while verifying the caste status of the petitioner, and various vital aspects were not considered by the inquiry officer. The Joint Secretary of the Government of Assam, Home and Political Department, also provided a copy of the inquiry report of 31/7/2023, which was conducted to ascertain as to whether there was any malafide intent of conduct on the part of earlier inquiry or not. Annexure 4, Lordship will kindly see. Page 49. Page 50, Lordship will kindly see. Here, SP is not
Just
at
a minute,
fault. Page 49.
Mr. Saket, just.
Is page 49?
Page 50, Lordship will kindly come. Page 49 says the CID SP was not at fault.
Okay.
But next page, Lordship will see.
Yes.
With reference, I would like to inform that the inquiry was conducted in the manner the inquiry is conducted by Punamjit Nath, ASP Deputy Sir. The inquiry revealed that Inspector Dibbojyoti Dutta, the inspector, had made perfunctory inquiry. However, it has been ascertained that there was no malafide intent or conduct on the part of the SP CID. The first page only CID's reference is here.
So this
Here,
inspector, the then inspector has made a perfunctory inquiry. What is the basis of that?
yes, that report, Lordship, I am coming. Next page.
Come.
Page 51.
Yes.
Submission of additional information to the CID. The first part is narration up to paragraph 4, paragraph 5, serial number 5. Inspector Dibbojyoti Dutta has submitted an inquiry report to the Superintendent of Police CID on 3/10/2019 in response to the above mentioned letters received from the Director of Welfare of Plain Tribes and Backward Classes Assam. The detailed report in connection with the matter has already been submitted on 17 July 2023. The following observations are being made. In the OBC certificate issued to Monsoon Borkakoti by All Assam Backward Classes Association, 13/11/2006, and countersigned by the then Extra Assistant Commissioner, Additional Deputy Commissioner Jorhat, the name has been mentioned as Monsoon. The spelling is different. The Diganta Borwa, the village headman of Sekonidhara Gaon, Jorhat East Revenue Circle, under whose jurisdiction Srimoti Monsoon Borkakoti currently resides, had provided a copy of the letter he received from Surendranath Bora, the then village headman of Doirongia Goalgaon, informing that late Siva Prasad Borkakoti, father of Santanu Borkakoti, that is the father of the petitioner, along with his family, was residing in Doirongia, Goalgaon, Moja, Misamari, Jilla District, Golaghat, before 1953, and they belong to Coast community. This is one part. He was never a Coast community, he was a Kolita community, and his house is at Silpukhuri, Guwahati. Sri Surendranath Bora, the then village headman of Doirongia, Goalgaon, denied issuing any such letter confirming that they belong to Coast community, thereby contradicting the statement of Diganta Bora, village headman of Sekonidhara Gaon, Jorhat, so and so. C. Srimati Monsoon Borkakoti had received a letter dated 26 March 2019 from the Deputy Commissioner Jorhat, asking her to bring the original documents for verification. Later, the aforesaid letter was found to be fake, for which R.A. Korati in IAS, the then Deputy Commissioner Jorhat, had submitted a written complaint dated 3rd April 2019 to Officer in charge Jorhat PS against unknown persons for faking her signature and official seal. On receiving of the complaint, a case was registered at Jorhat case number so and so. The following points were not incorporated in the earlier Inquiry Officer Inspector Dibbojyoti Dutta of CID in his report submitted by Superintendent of Police CID dated 3/11/10/2019. The above mentioned observations may be taken into account if deemed fit in ascertaining the malafide intent of the part of the previous inquiry officer.
So far as regarding this C point is concerned, what
Yes.
is the relevance of this C?
That relevance is like this.
That she received a letter.
Letter,
when
and they were trying to, I'm coming because this is the initial. Subsequently, a detailed report, we have annexed it. I'm coming to that also. Everything will get very clear. She tried to project that her certificate was verified by the Deputy Commissioner, and everything was found to be genuine. That was the intention. I am not on that because this case was finally came into FR where it was the finding that the allegations are correct, but who is the culprit, they could not find it out. Identification of the unknown person could not be ascertained. That is one part.
This Diganta Barua, village admin, has earlier certified that they belong to coach community.
Yes. And he later on says that I do not, I have not. That is why the Jorhat original certificate might have.
Nay, then this Diganta Barua, village admin of the so-and-so has given the certificate. Shri Surendranath Vora, the then village admin of so-and-so denied issuing any such letter.
Absolutely.
This letter is by Diganta Barua, not by Surendranath Barua.
Lordship, this is the initial. Now we went for a proper inquiry with a very senior officer. And what is the findings? I'll place it now, Lordship. This is the initial. From here, this gentleman, the IO, his intention was because he was more relying upon Supreme Court judgments instead of going to the basic facts. The basic facts which he have disclosed that the daughter has accepted the caste of the mother. And the Supreme Court judgment says the mother. And he also says, he never said, where is the father staying? Are they separated? Are they divorced? Are they single mother?
Even though
These are very important. These are very important aspects.
Staying with them, and but she follow.
That way, Lordship, it will become chaos. If Lordship says that from this honorable court, then it will create a whole chaos in the whole society. Everybody will say that I will accept my wife's caste, I will accept my mother's caste. That is not the norms, Lordship. So far as determination of caste is concerned. That will upset the whole scheme of reservation. I am not on that. Further findings is very important. This year, the government did not act upon this. The government did not act upon this. The government acted upon the additional affidavit. Lordship will kindly take now. How their whole family tried to dodge the administration. The father took a caste certificate in 2019 as OBC. The brother who is studying, he is a general candidate. The mother took her first caste certificate in 2019. All these things have found out. The parents are staying happily, but the father was posted in Jorhat. The mother's land was taken and the father constructed the house and they are happily married. The central government has issued a notification in what situation the mother's caste can be taken by the children. They have to be deprived from all amenities of a general candidate, general person. And the mother should be living singly or divorced or separated. Those norms, Lordship, will have to be included here. And now, if Lordship is pleased to take my additional affidavit now. Paragraph 3, page 123. The deponent respectively begs to state a person to the direction issued by the competent authority, the SPCID Assam, by his letter dated 26/12/2023 has submitted a detailed inquiry report on the status. Hereafter only we filed a review application. Till this, we did not file review application on the 31st August, later. A detailed inquiry report on the basis of the caste certificate in respect of Monsoon Borkakoti, ALRS, under suspension, as submitted by the inquiry officer, Srimoti Moromi Das, APS, Deputy Superintendent of CID Assam. The aforesaid inquiry report submitted by CID clearly indicates that Srimoti Monsoon Borkakoti is not entitled for the OBC certificate as her father belonged to the general caste and she received all kind of supporting from her father. Now Annexer A, Lordship here. This report, after this report only, we decided to come before this honorable court for a review. Page 126. The initial and final report, initial report was there and the final report on 26. Submission of inquiry report on caste certificate in respect of Monsoon Kakoti, 26 December 2023. Now, I'm going to page 127 now.
Yeah.
With reference to the subject, I am hereby to inform that I was entrusted to conduct a fresh inquiry on the caste certificate of Srimati Monsoon Borkakoti. After a detailed inquiry, verification and examination of documents, records, etc. pertaining to the matter in Jorhat, Golaghat and Guwahati, I would like to submit here with the following. Srimati Monsoon Borkakoti, daughter of Dr. Santanu Borkakoti and Srimati Purnima Datta, was born at Sekonidhara Gaon in currently residing at Sekonidhara Gaon, Town Moja, Jorhat, East Revenue. This is in the heart of Jorhat city. Along with her parents and younger brother Minmoy Borkakoti. Her father, Santanu Borkakoti, is a retired medical officer appointed to Class 1 cadre of Health and Family Welfare Department, Government of Assam, and is residing at the same place with his wife and children. Her mother, Srimati Purnima Datta, who is also a government employee, is currently working in the Irrigation Department of Government of Assam as Senior Assistant. Dr. Santanu Borkakoti was born and brought up in Guwahati, so and so, last line. They belong to Kolita community, which is general category. No dispute on that. 4. Srimati Purnima Datta was born to late so and so, brought up in Sekonidhara number 3, Town Moja, Jorhat, East Revenue Circle, in the Club Road. It is the main posh area in Jorhat, which is located in the heart of the city. She has one sibling, namely Puspa Datta, who resides at Bishkoynagar, Jorhat, with her husband.
So if she is residing in a posh area.
Very important.
She can't be belong to a.
No.
Community.
That what I am saying. This has relevance, Lordship. When I place the central government's notifications, these are very relevant issues. I can be a SC here. I cannot be a SC in another place. The village headman, Sri Digonto Bora of Sekonidhara village, has stated that they belong to Coast community. The maternal home of Monsoon Borkakoti, daughter of Srimati Purnima Datta, was reconstructed 10 years back. The land dates back to her great-grandfather, late Rajan Datta and late Krisumi Datta, who also has 2 daughters. Srimati Monsoon Borkakoti completed her schooling in Don Bosco High School, Lichubari, in the year 2007, Jorhat, and passed out with 72% and secured letter marks in 3 subjects. She completed her higher secondary from Luit Valley Academy, Jorhat, in 2009, with state highest mark in political science. She completed graduation in Cotton College in political science in the year 2012, where she secured first class second position with distinction and completed her master's in political science from Cotton University with first class in the year 2015. So she started her academics with a missionary school and completed her education in a very reputed university. It is pertinent to mention that during her higher studies, she was residing at her father's ancestral house in Silpukhuri, Guwahati from 2009 to 2015. An OBC certificate dated 13/11/2006 was issued in the name of Srimati Monsoon Borkakoti, daughter of Santanu Borkakoti, from the office of Assam Other Backward Classes Association, which was purportedly countersigned by an ESC, Jorhat, showing that Srimati Monsoon Borkakoti belonged to Coast community. This certificate was used by Monsoon Borkakoti for claiming the benefit of OBC in her APSC examination. It can clearly be seen that the name in the certificate is differently spelled. Srimati Monsoon Borkakoti herself admits that her mother belongs to Coast community, whereas her father belongs to general category. During the course of inquiry, visited the office of Assam Other Backward Classes Association in Jorhat, Congress Bhavan, to verify the documents submitted by Srimati Monsoon Borkakoti at the time of applying the OBC certificate. It is to mention herewith that the OBC certificate of Srimati Monsoon Borkakoti was issued on 13th November 2006, but the records available in the office are of only after 2007. The office bearer of the Assam OBC Association Jorhat informed that they have not kept any record up to the year 2007 and also showed one proceedings dated 9/9/2007 relating to destruction of records, documents, etc. During the course of inquiry, the inquiry visited the DC office Jorhat to verify the documents submitted by Monsoon Borkakoti at the time of applying the OBC certificate. They stated that no such records are maintained in the office as documents were issued by All Assam OBC Association. During inquiry, it is found that Monsoon Borkakoti has received a letter dated 23/3/2019 purportedly from DC Jorhat asking her to bring the original documents for verification. Later, the aforesaid letter was found to be fake for which R.A. Korati IAS, the then Deputy Inspector, Commissioner of Jorhat, had submitted a written complaint dated 3/4/2019 to Officer in Charge Jorhat against unknown persons for forgery of her signature and official seal. The case was investigated and the suspected documents were sent to FSL for examination. After completion of the investigation, the IO returned the case in final report by Jorhat dated 31/2020 as true, but no clue of involved accused persons, and sent the case diary along with relevant documents to the Honorable Court. During the inquiry, it has come to the light that Dr. Santanu Borkakoti applied for OBC certificate in the month of February 2019, the father, who is a general candidate. Sri Digonto Borua, the village headman of the Sekonidhara Gaon, forwarded the application stating that Dr. Santanu Borkakoti belongs to Koch community. Sri Digonto Borua stated that he forwarded on the basis of a certificate purportedly issued by the then village headman of Doirongia Gwalgaon, Dergaon Golagar, Sri Surendranath Bora. The application was rejected as per the statement of Sri Komal Gogoi, President, Jorhat District Other Backward Classes Association, after a complaint received from Anti-Corruption Liberation Union. During the inquiry, Sri Surendranath Bora, the then village headman of Doirongia Gwalgaon, Dergaon Golaghat, was examined. He stated that the letterpad and the signature was his, but the content of the letter was not written by him, and he also stated that in writing, Annexure L. During the inquiry, a letter was submitted by Anti-Corruption Liberation Union, Jorhat. The letter was addressed to the Circle Officer, Dergaon Circle, dated 29/1/2021, from the then village headman of Doirongia Gwalgaon, Dergaon, Golaghat, Sri Surendranath Bora. The letter stated that Dr. Santanu Borkakoti rented a house in the same village for 3-4 years, and the landlord belonged to Koch community. It may be assumed that on the basis of being a tenant in Dergaon, and also on the strength of OBC certificate of his daughter, Sri Monsoon Borkakoti, Dr. Santanu Borkakoti applied for OBC certificate in Golaghat, Annexure M. Another document regarding furnishing of RTI reply from Additional Deputy Commissioner Golaghat addressed to Anti-Corruption Liberation Union, Jorhat, was submitted. It stated that Dr. Santanu Borkakoti did not have any ancestral property in Doirongia, Gwalgaon, Dergaon, Golaghat. During the inquiry, this is very relevant, a fake OBC certificate issued in the name of Dr. Santanu Borkakoti bearing caste certificate number 9447 dated 19/3/2019 was collected from Anti-Corruption Liberation Union, Jorhat. It is assumed that the original copy must be in the possession of beneficiary, namely Sri Dr. Santanu Borkakoti. However, when we requested for meeting him to question about the certificate, his daughter, Sri Monsoon Borkakoti, restrained us on the pretext of her father's ill health. Moreover, a formal communication by memo number so-and-so dated 14/12/2023 was issued to Monsoon Borkakoti, but till that there is no response in respect of the said purported fixed certificate. So they are trying to hide it now. Sri Purnima Datta was issued the OBC certificate on 6/11/2019. Although her service record in 2006, which was produced before the division bench, so that she is a coach. An RTI was filed by representative of Anti-Corruption Liberation Union, Jorhat, praying for the official record of Monsoon Borkakoti's brother, Srimati Mrinmoy Borkakoti, for admission in BSc, Bohana College, Jorhat. The reply from the PIO, Bahana College, Jorhat, stated that the caste of Mrinmoy Borkakoti, son of Dr. Santanu Borkakoti, is recorded as general category. So the brother is a student, and he is a general category. After going through all the documents, records, and examining the persons concerned, I have come to the conclusion that Srimati Monsoon Borkakoti's mother, Purnima Datta, belongs to Koch community, which is a recognized OBC. Srimati Monsoon Borkakoti's father belongs to Kolita community, which is a general category. Srimati Monsoon Borkakoti used the OBC certificate issued on 13/11/2006 in the name of Monsoon Borkakoti, daughter of Santanu Borkakoti. Srimati Monsoon Borkakoti, ALRS, under suspension, resided in her maternal house in Jorhat, and by her admission, her parents are living together and have a happy married life. During the inquiry, it was well established that Monsoon Borkakoti's parents were never separated nor divorced. Her father took care of her all. Her father took care of all her along. She did not suffer from any disabilities socially, economically, and educationally. In fact, the house they are residing was rebuilt 10 years ago, which reveals that the house constructed after marriage by her parents, that means father and mother together, and her father was actively involved in the construction of the house. She stayed at her father's ancestral residence in Silpukuri, Guwahati for her higher studies from 2009 to 2015, which also proves that her father have never abandoned her nor neglected her at any point of time. It is also pertinent to mention that both her parents are class 1 and class 2 government servants and thus falls in the creamy layer by OM dated so-and-so, 13/9/2013. It is pertinent to mention that Dr. Santanu Borkakoti have tried to manipulate the inquiry by applying the OBC certificate in the year 2019, for which he was not eligible, and also by procuring one fake OBC document from Golaghat district in the year 2019. In my opinion, Dr. Borkakoti tried dubious method to procure OBC certificate in 2019, and appropriate criminal prosecution may be initiated in this regard. According to the government OM dated 3/10/2019, published by the Ministry of Social Justice and Empowerment, and government OM dated 21/5/1977, published by the Ministry of Affairs. I would like to place this at a little bit that I'll place this whole document. Therefore, Monsoon Borkakoti is not entitled to claim the benefit of OBC as her father belongs to general category and her parents were never separated, divorced, and she received all kind of support from her father. Let us go to this annexure, Lordship. That annexure is at page 181, annexure S. This notification has been issued on 3rd October 2019 by the Ministry of Social Justice and Empowerment, Department of Social Justice and Empowerment under Government of India. Caste claim of offspring of separated, divorced, and single women. I am directed to say that comprehensive legal position about the status of the offspring born to couples where one or both of the spouses is or are members of scheduled caste and or scheduled tribe was circulated by this Ministry of Home Affairs dated 21/5/1977. It has been represented to this department that the said guidelines were silent regarding caste status of offspring of separated, divorced, or single women, whether caste certificate can be issued to the children of separated, divorced, or single women on the basis of caste of their mother. The Supreme Court in Ramesh Bhai so-and-so case versus State of Gujarat stated, in an intercaste marriage or marriage between a tribal and a non-tribal, there may be presumptions that the child has the caste of the father. This presumption may be stronger in case where in the intercaste marriage or marriage between a tribal and non-tribal, the husband belongs to a forward caste. But by no means of presumption is conclusive or irrebuttable, and it is open to the child of such marriage to lead evidence to show that she was brought up by the mother who belonged to the scheduled caste, scheduled tribe. By virtue of being the son of a forward caste, father did not have any advantageous start in life, but on the contrary suffered the deprivations, indignities, humilities, and handicaps like any other member of the community to which her mother belonged. Additionally, that he was always treated as member of the community to which the mother belonged, not only by that community, but by people outside the community as well. In the GNCT of Delhi, instruction of issued of caste certificate inter alia requires the applicant to produce the caste certificate of a relative from the paternal side. The said instructions were challenged in Delhi High Court, so the court said, the practice of issuance of caste certificate based on the caste of the father is not without exception. In certain cases where it is established that the children have grown up in a notified community or tribe or have suffered all the disadvantages and deprivations belong to such community, the office order could not come in the way of issuance of caste certificate certifying that the applicants belong to a caste of their mother. Next, in view of above observations of the Supreme Court and Delhi High Court, where it is established that the child has been brought up in the surroundings of a notified community to which the mother belongs. That is why I was saying that in Jorhat, they were staying in a posh area which has a multicultural presence. notified community to which the mother belongs to and has suffered the deprivations, indignities, humilities, and handicap like any other member of that community. And he or she was always treated as a member of the mother's community, not only in that community, but by people outside the community as well. Then such a child of separated, divorced, single has to be treated as a member of the scheduled caste community and would be entitled to receive benefits as such. However, each individual case will have to be examined in the light of existing facts and circumstances in each case. So this notification on the basis of Supreme Court or judgments and Delhi High Court judgment was in place. The perfunctory opinion of the inquiry officer at the first stage submitted in the month of October 2019. He said that the girl accepted the caste of her mother. That is an opinion given by him. To further going ahead, that the daughter can accept and she can claim the caste status of her mother, but there are certain preconditions. He did not look into those aspects. Now, in the subsequent inquiry, all these details were found out. If these details are very clear now, that the parents are always together, they are leading a very happy family life. The brother is not entitled, so he is not claiming it. The certificate was issued in 2006. Thus, relevant documents were not produced by that authority by saying that from 2007 only we have kept all the records. So this is the area when all these facts have come to the eye of the government lordship. Review to ketia fail koribo? Iku diya jata. ये माना जाता है कि 20 number of that.
Mr. Sekya,
Lordship.
Let us for a moment assume that on facts you make out a case. What is that you are ultimately seeking here? Review. If the review is allowed, then what will happen? The appeal will be revived.
Appeal will be revived.
But the appellant is not before us. The appeal will be dismissed for default.
And the notice was issued to the other side.
No, but if they don't come,
Who,
the appeal will be revived and it will be dismissed for non-prosecution. Single judge's order will be revived.
I think their counsel was present the other day. They even argued regarding a non-familiar issue also. We did not argue at any point. They argued, detailed argument is there.
Creamy and non-creamy layer is altogether different.
Different. That's why I'm not, but they, in fact, they.
So are you understanding the query? Review will be allowed and the writ appeal will be dismissed for non-prosecution. What benefit will you get? Because you can't press the appeal.
No, review will be allowed, then we'll get the opportunity to place.
No. So I'm saying, assuming.
Yes.
Assuming that the review is allowed.
Lordship.
The writ appeal revives. The appellant is not there, the appeal will be dismissed.
That situation till now has not come. I'm sure Rupjit Day is the counsel and AK, but they were more aggressive.
You will make sure that the appellant should be represented.
No, he was always here. In fact, he was sitting at 2 o'clock also.
No, but he is
They were watching. They were watching me toiling their case.
He is not visible.
They will not come now. They will come when they will see,
Now
they are fence sitters.
they lost the interest in this.
No, I don't think they are in there because he was sitting here. The other day also they were sitting and very senior counsel, Mr. A.K. Bhattacharya argued this case. He can. Hmm? Hmm. Itu memukul penyebab itu bom sol template itu ulang oh tadi aku kami semua itu mau daily mata biar Yo, buka pula. Kami biasa masuk buka. Ini pala buka, ini pala buka, ini pala buka, ini pala buka. He has come, Lordship. They were watching.
बुला के लाए आप।
बुला के नहीं, he was available.
Which fence, Mr. A?
They have taken up
Mr.
office
Saika
also.
says you were fence sitting. So you have not preferred any review against the judgment. So according to you, the judgment is fine.
Okay. You are not in contact with the client. How can you appear in this review petition? Nobody is representing even.
No, otherwise, Lordship, we will file the review.
That is a very
with
peculiar
seeking leave of-
situation. You are aggrieved by the single judge's order and the division bench judgment you accept. They are not aggrieved by the single judge's order, but they are aggrieved by the division bench judgment, which affirms the single judge's order. So we find that leaving aside the other aspect, whether on sufficient materials, I think that is the finding in this Netaji Cricket Association case, that sufficient materials.
The very recent judgment very clear. The subsequent evidence, which has very critical for deciding the issue.
But who can apply
Only
for
subsequent development will not help. The Netaji,
who can apply for review?
anybody, any aggrieved party. That law, that judgment I will place. Law is very clear, Lordship. That was the query of the bench. On the, I was prepared, Lordship, for that.
Please show that.
Yes. In fact, first let us go, who can file review? Any aggrieved party.
Yes.
The language is very clear. Initially, the Supreme Court said that only the parties in the litigation can file review. Now, the third party is also allowed, who is not a party in the case. It has been widened now. Yes. 114 पे ले लें। 114 में judgment क्या होगा? Judgment
Formidable arguments.
judgment क्या होगा? और margin होगा। Be- Before going to the law, just 2 pages I would like to show.
Yeah.
From the report, page 158.
158.
158. It's a part of the inquiry report. How the father on 16/2/2019 applied for the caste certificate as coach. This inquiry was very detailed, Lordship. We have got everything here. 158, serial number 4FG, mobile number, then caste. The father said coach, and the signature of the father is there.
Yes.
We have got the counterfile of the certificate issued to him. And next page recommended. Next page 159 recommended for the certificate by the competent authority. Now coming to the Gaubura certificate at page 164, it is in vernacular. My Lord Justice Kiam would be able to. তেওঁ অসমীয়া জাতিৰ উপজাতি কোচ সম্প্ৰদায়ৰ লোক আছিল from Doirongia Gwalgaon. These are the frauds they have done. Straightway, a doctor working in the state government.
Other was member of the court. Which are they obviously. He never came.
Yes.
And the school record also says the brother is a general cadet.
Yes.
The certificate counterfoils also we have annexed. Everything is there. The records from the school regarding her brother. These are part of the affinity test, which is endorsed by the Honorable Supreme Court regarding caste verification and also indicated in paragraph 13.5 of the Madhuri Patil's case. Now, section 114 of the CPC.
That's the enabling provision. We come to order 47.
47, because enabling provision read with the rule order 47 rule 1.
Any other sufficient clause?
I have lots of submissions.
Order 47 rule 1, please read. There is a clause, any other sufficient ground.
That is there. No, I'm not on ground. Whether, because we did not file the appeal, the query of this honorable court was that
Any person aggrieved.
any person aggrieved. So the Supreme Court says any person includes all the parties in the litigation and also third parties if they can satisfy the court that they are aggrieved by that order. They can also seek review. So review says order 47 rule 1, application for review of judgment. A person considering himself aggrieved by a decree, etc., and who from the discovery of new and important matter of evidence, which after exercise of due diligence was not within his knowledge. This is very important, Lord. And could not be produced by him at the time when the decree was passed or order made, and on account of some mistake or error apparent on the face of record or any other sufficient reason, desires to obtain a review of the decree passed and order made against him may apply for a review of the judgment of the court which passed the decree or made the order. So I am not seeking that there is an apparent fault. There is no mistake. I am saying once more, 1/6/2023's judgment, as well as the 24 November 2022 judgment, there is no flaw. The flaw is with us. I do not know whether our inquiry officer was hand in glove with the other side or not, but subsequent inquiry proves that he was hand in glove, and now he is facing the music. He's already under suspension. DP has been drawn against him.
The earlier inspector said.
Yes. He was already put to suspension. He was working in Duliajan police station as deposited doctor. He already action. We have nothing against this person, Lordship, but the finding should be genuine. He was stressing more on the Supreme Court judgment instead of finding the actual facts at the ground. Who dictated him all these things? The inquiry officer, vigilance officer role is to fact find. He is not supposed to give any opinion also on judgments. Page 185.
किसी ने लिख के दिया वो कितना कितना अच्छा रिपोर्ट कैसे
Page 185 for a moment. Lord.
Yes.
Page 185. On 3rd January, initiation of departmental proceeding against Inspector UB Dibbojyoti Datta, officer in charge Digboi Police Station. With reference to the subject cited above, I am directed to inform you that the, oh, I'm sorry.
That's
In the additional affidavit, Digboi Police is placed under suspension and a departmental proceeding is drawn up against him for his negligence and dereliction of duty
there.
in connection with a perfunctory inquiry, etc., from the Inspector General of Police Administration. So, who can seek review, lordship? Any person who is aggrieved by the judgment. And here also, those who are not, have not preferred appeal. That is also indicated. We have not preferred appeal. So that road is open to us. Had we filed appeal, it would have been more difficult.
Just a minute, Mr. Secretary.
Luka dekham na, outer dekham. Neta dekham.
1 second, there is a something. Enter. No. You want to do special.
It is Union of India file kora nasil na.
हाँ वही तो चाह रही है 15-20 दिन में ये हम तो डिसाइड करना है वो ये बता प्रैक्टिस के the only option with the state level is to close. So that will have to hear in the receipt. The beginning the receipt so already follow that. Subsidy again आता है तो लेकिन take this provided the employee company. They are creating many condition है condition judgment में भी पोस्ट किया judgment में भी पोस्ट किया in case the report is in paper and found to be genuine. They are reading evidence so that it's not genuine. That's their case. They succeed in simultaneously reading that. Then this finding will go. In that case, you can pick it up. Pin 7 will not apply. It's not found to apply. Yes, okay, good. For the people, and how many Mr. Sekia, see, we have heard you for about 1.5 hours. And Mr. Chaudhary is yet to argue. Now, subject to what Mr. Chaudhary may argue, we are just tentatively thinking. The division bench has put a halt to the process by taking Q of 13.7 in Madhuri Patil. But there is a rider that if the report is found to be genuine and true, then only the rider will come into play. So you are leading all these materials to show that it is not genuine and true. You may be right, you may not be right, we don't know. After hearing Mr. Chaudhary, we'll see. But if it turns out that the court is convinced that there are materials to show that this is not genuine and true, in that case, 13.7 will not come into play. And in that event, the matter will be open to reconsideration and probably it will be a fit case for review. But even if that happens, you will have to reinstate her, because even if the review is allowed and the division bench judgment is recalled, single judge's judgment will remain.
That has merged. That law also I have found out. There is only one judgment in operation.
That's one part. Other part is you want to now conduct a fresh inquiry. That's your prayer.
Inquiry we have already conducted. The main part, SOCOS notice was also issued. And there is a verbal direction of this honorable court.
You want to now take that process forward and come to a finding.
Yes.
So once today you can't presume what will be the outcome of that process. You can't presume. As a state, as
that
a
is why my prayer is that kindly give us 15 days time.
No, Mr. Sekar, please understand the query. State as a fair employer, you cannot presume what will be the outcome.
Absolutely.
So at this point of time, she cannot be restrained from joining back her service. You can find her certificate to be false, proceed and terminate her. That's okay. There's no difficulty.
Yes. Now,
but you can't say that till we do it, even if it takes 10 days, 15 days, we will not reinstate it. That is another stand of the state.
Now, what is the law regarding complying the honorable court's direction? A contempt is hanging against us.
That will take care.
That will be taken care. But we are not complying the order, whether it is a willful and deliberate violation of the honorable court's order. That is the area where Lordship will have to look into now. I'll place.
That will take care. That will take care.
Now, when we have found out that the inquiry is prima facie not correct. Prima facie. So it is our duty, if Lordship opens up the writ appeal, in the writ appeal, we'll have to seek a leave of the honorable court to place these subsequent documents. And there is a verbal stay order. That's why otherwise the inquiry would have been completed. We did not go prosecute the criminal case also against the father. And also the inquiry where SOCOS notice was given to them. They have not challenged the subsequent SOCOS notice as well as the inquiry till now.
You have to show some deference to the court order also. Why are you so rigid about not allowing her to join?
Comply it in the month of March.
Yes.
Again in December. So when we found that this is a clear case of fraud, in that situation, whether we should give advantage to a person who does not deserve that advantage, and we are not sitting, immediately we came and placed everything before the court. We are taking the court into confidence from our side. Whether Lordship will accept our submission, that is a different thing. But we are not hiding and we are not sitting idle. The person against whom the contempt has been registered, he sent the file in the month of March for compliance. Then again in December. Now, one very important issue, which is very relevant in today's context. The gentleman who became MP from Pokrajhar constituency in 2000, no, Lordship, there's a relevance. There's a relevance. That's why I'm saying in 2014 and 2019, he became MP and got all the benefits. When the complaint came to us in 2018, we conducted the inquiry. 2021, it was here. And in January 2024, the decision of the inquiry committee was that he does not belong to that caste. On 18th of April, this honorable court finally gave seal to our findings. 19th, he has to submit a nomination paper. So he all along for 10 years, he enjoyed all the benefits as a MP and he became a very respectable person on the basis of a scheduled caste plains certificate where he is shown as Boro Kochari. STP, scheduled tribe plains, Boro Kochari. Next day, he went to the nomination counter and submitted a certificate that he belongs to Rabha community. In one day, his caste changed. So this is a fraud. This is a fraud on the society.
That is the individual.
That is a fraud. That is why he did not deserve to be a member from a reserve category seat for 10 years, but he availed that benefit. Now it cannot be taken back. Maybe criminal prosecution will go against him. I do not know. I'm not commenting on that also. But he deprived a genuine candidate of that particular area. That area was not represented by a scheduled caste tribe. STP.
Your concern is very genuine.
Here case,
belonging to
now if
your
lordship,
category
if all the
is
facts
not
are,
supposed to get the employment as being your category candidate.
we did not throw her out. The complaint came from her community's people. We looked into it. Now our duty is, that's why I'm saying all along that these are the legal remedies which we can avail. That's why we are doing it. Had there been no review provisions under CPC, we would not have come. That's why my yesterday's submission was that we will explore all legal remedies. If we fail, we'll comply. If we succeed, the subsequent decision of the court will prevail. We are not saying, we are giving full honor and majesty to the honorable court's direction. That is why we have come with the review. We are not sitting idle and going away. There is no deliberate, there is a no willful violation of the honorable court's order. If so much of materials are before this order, my submission would be that if
you will not be able to conclude.
No, Lord. Tomorrow, Lordship.
30th May.
30th May.
Sorry, 30th April.
30th April. Lordship.
Yes, Mr. Patel.
My lord, time and again, the learned AG submitted. My lord, that with the subsequent development. I will show from the record.
No, you argue, we are deferring the further hearing till 30th of April.
No.
That's all. You have taken note of his submissions. So the formulations were very clear. According to Mr. Saikia, this certificate has been obtained by fraud, and this fact was not correctly brought on record by the inspector, against whom now departmental proceeding has been. So therefore, the basis of finding of the single judge and division judge was not correct, and that is sufficient ground for review. Only that much. Beyond that, we are not going. If they succeed in that, we'll recall the order and hear the writ appeal. And if they don't, then the matter remains as it is. That's all. Nothing more.
Arguments are heard in part. This on 30th of April.
Deeply obliged.
The dates we have. Which one? Pity. What is this? This is also for the heading.
Supplementary list item 50.
Hello.
Lordship, matter relates to appointment of the petitioner as health and malaria inspector in the NF Railway, Lordship. I have approached against the order of the learned tribunal where the order was, my case was dismissed, Lordship. So respondents have not yet filed reply, Lordship. Reply is necessary. Before the tribunal, it was dismissed without.
For the respondent.
B. Chakraborty's name has been shown.
Interim order passed earlier.
Interim orders to be continued till next day, if any, to be continued till next day. 2 weeks.
Daily list for final disposal item 42 to 44.
The last occasion, we remember Mr. Das.
Was supposed to take some instruction.
Some instructions regarding the.
My proposal was, your lordship, that 15 lakhs has been deposited, that amount may be given to us, and the rest part, your lordship may refer it to the labor court, your lordship.
Here come.
Das,
I'm sorry, my lord. I'm so sorry, my lord.
your instructions.
I'm sorry, my lord. I'm so
Have
sorry.
you completed your instructions?
But a bit of time is required, my lord. If your lordship just allow a week
Granted
time,
you time, 25 lakhs we offered, I think, so on
No, no.
that day.
my lord, just a week time I'm asking, my lord. If it's not inconvenient to your lordship, my learned friend, I'll come back.
Interest. Enough time was granted for interest.
No, your lordship has granted. I'm not saying your lordship has not granted.
Then
We deposited
have to-
15 lakhs also as per in
Then
person.
we'll have to order for interest.
No. We deposited at 15 lakhs also for registry, man.
That is there, but so
Yes.
far as regarding, I think so what we remember on the last.
No, your lordship is right. Your lordship is
we
correct.
asked you to for 25 lakhs.
No, correct. Your lordship is right. Right. Correct, your lordship is right.
Labor court will decide.
And the labor court will decide.
Yeah, that's.
Rest part.
Because some liability is there.
No, that's true, man. I told your lordship, man. Some liabilities will be there, man. I can't say that no liabilities are there.
Advocate assisted by so and so. Praise. A week's time to complete his instructions. From the appellants whether they are ready to pay a certain amount as part payment of compensation till the matter is decided by the labor court as per the order passed by the learned single judge.
Obliged.
Deeply obliged.
Your lordship may fix a date, your lordship.
Second one.
Obliged.
ये next वाले में क्या देते हैं? उनके matter से उन fix a date of
For hearing, item 45.
Yes, in the remaining matters, we are fixing some date since just honorable brother is having another bench in SB. We'll fix a date in that. Yes, which date? 45?
After 10 days, maybe.
15th May, whatever the date after 15th May. This 46.
Any day, but not tomorrow, Lordship, any other.
Mr. Chaudhary, you earlier you offered that I'm going to
No,
persuade the
Lordship,
university and now
Lordship-
you are residing back.
So Lordship, Lordship
Okay,
also
we'll
put it on me.
consider it.
Lordship also put it on me, no, Lordship. I have taken it up with the university, Lordship. But
You assured this court, I'll get it done.
Lordship, I cannot do that when there's another authority in between, Lordship. If,
You are the authority in
no,
yourself.
no, the authority is the UGC. If they give me the green signal, Lordship, there is no issue at all.
What do you have to say, Mr. Chamua? What is your?
So far as the relief claim by the appellant is concerned, my lord, we have filed our affidavit in the writ petitions. And just today, when I have gone through the whole things once more, what I have found, his pay scale was based on a judgment passed by this honorable court, which has attained its finality. Therefore, my lord, It doesn't require any special permission from any authority.
Then you take that stand, we'll close it. He is saying because UGC is not willing, that's why we can't.
No, it's not like that. We file our affidavit saying that he is not entitled because these are the rules. But rightly or wrongly, there is a judicial order that attains its finality. Nobody has challenged neither UGC nor the university.
No, as per the court's order, he was fixed in which scale?
12,000, 18,300.
Yes,
By
18,000.
the court's order.
By the court's order, yes.
But no such scale is there in the.
No, that the difficulty was like this, my lord. He went from a different authority. He was under he was attached with one of the honorable judges here of this court. Then there was some deputation or sort of exchangement, and there he went into the university. His pay was protected, and university agreed that his pay as it was before that will be continued. But in the university's scale of pay, this particular scale was not there. So that is why the problem arose. But then it got resolved by the judgment of the honorable court. So it got resolved. The dispute at that point of time got resolved by the honorable court's judgment.
31st May. Chalo. This list on 31st May. What about 47? Item number 47, 48, 47.
My lord, item 47 may be taken up on Friday, my lord. There is an urgency, my lord.
Lordship, I'd like to say that not on Friday, on the very next week, Lordship can take it up.
No, on Monday then, my lord. There is an urgency, my lord, on Monday, my lord.
Second of May.
Can it be on Monday, my lord?
Why?
My lord,
What's suspicious on Monday?
my lord, on 3rd, my lord, it was.
She has made a request that not on Monday, then not on Friday, then 2nd of May.
My lord.
Much obliged.
Most of it.